Well, hello, all you wonderful people. Um, so a couple weeks ago, I was perusing the local newspaper, the Salt Lake Tribune, and I came across an interesting article. The title of which, These Utah Brothers Want the Supreme Court to Remove Joe Biden from the White House and Reinstate Donald Trump as president. Um, and the article is written by Brian Schott. So I've been meaning to do this for a little while. Fell behind, but spoiler alert: we have a resolution in this case. So uh, before I jump into the court documents, though, let's skim this Tribune article. So they're suing, claiming that because Congress refused to investigate claims of foreign interference in the 2020 presidential election, they want Joe Biden and Kamala Harris kicked out of office. And they want every member of Congress, both the House and Senate, who voted to certify the election, they want them kicked out of office, and all of them to be barred from ever holding office again. And this includes former Vice President Mike Pence. They want Donald Trump immediately reinstated as president. And I was going to save this as a surprise for later, but it's going to come up in the article here anyway. They want $2.9 billion for themselves for their troubles. So this is a lawsuit brought by the Brunson brothers of Ogden, Utah. So the specific case we're discussing today is brought by Rayland Brunson, but his brother Loy has an identical suit, but it's not the one that they took to the Supreme Court. So, but Loy ran for the Republican nomination for the U.S. Senate for Utah in both 2018, where he ultimately lost to Mitt Romney, and 2022, where he ultimately lost to Mike Lee. So the level of delusion here, and let me be clear, this is a politically adjacent topic. It involves politicians. This is not political commentary. This is legal commentary. Please, please, please don't blow up my comment section with political arguments. That's not what this is for. This is for amusement. So please, please, please be respectful to each other and to me. And to these guys, don't reach out to them. They're nutty enough. They don't need harassment. But they say in their suit that not having a president or vice president in office is a national security risk. So Trump should immediately become president. And although this ignores the presidential line of succession, which, if you remove the president and vice president, puts the Speaker of the House, and then it puts the president of the Senate, the pro tem, basically the top senator, and then it goes Secretary of State, I believe, and through various cabinet positions. Donald Trump is not in the presidential line of succession anywhere. So the Tribune article stops its analysis at Speaker of the House, but assuming, although at the time they filed the lawsuit, Nancy Pelosi was Speaker of the House. Kevin McCarthy is now, and I'm not sure if he's mentioned in the lawsuit or not. So, I mean, if they were successful and he's not, then it would be President McCarthy, which I'll just leave it at that. But the reality is it would be the Secretary of State, most likely. But in an interview with Roger Stone, Loy Brunson, another of the brothers, said it's very possible that Donald Trump could be president of the United States in the next few days. So, as part of their social media campaign, they've asked followers to write a pair of letters, one to the Supreme Court in support of the case, which letter flooding the Supreme Court isn't going to do anything. Unless you submit a friend of the court brief, an amicus brief, you're not going to get any attention from the Supreme Court whatsoever. They're not going to look at your letters. They just don't care. And even for the amicus court briefs, friend of court briefs, you have to ask permission to file one anyways. But they asked to send a letter of support for the case to the Supreme Court, and the other to the brothers with $1 to fund their efforts. And they claim to have received more than 50,000 pieces of mail so far. So that's interesting to me, assuming each of those 50,000 letters had $1 in it. $50,000 to bring a lawsuit to the Supreme Court. So to me, that's I look at that as an attorney. And if they took this case into my office and said, we want to bring this case all the way to the Supreme Court, well, it would either cost $100, or if you look at the filings, that this has been a pretty open and shut case. So it could run into the millions to bring a case like this before the Supreme Court, but when it's dismissed so quickly, you don't run it up so fast. But if I were unethical and said, yeah, I'll take the case, I'd still be looking at least $100,000 of billing by now for the amount of work that went into this, for the number of filings, the types of filings. It would be expensive. But the $100 would be 1 minute spent listening to them describe their case, the next 15 minutes laughing and telling them to get out of my office and never return. Which that $100 bill would be closer to accuracy. So $50,000 though for bringing a frivolous lawsuit, hey, it's good work if you've got nothing else. But what makes this even more interesting to me? So they filed in Utah's 2nd District Court in June of 2021. So they filed in state court. And it was removed to federal court and then dismissed, brought to the 10th Circuit, denied, and then brought to the Supreme Court. Or at least they filed a cert petition with the Supreme Court. So this is what I thought was the funniest part of this article. It says, although Rayland Brunson is listed as the complainant on the Supreme Court petition and is representing himself, his brother Darren Brunson says he is the legal expert of the family. And we need to scroll down a little bit. And it says, according to Rayland's website, Darren, the expert in the family, the legal expert, relies on an online course titled How to Win in Court for his legal expertise. The course costs $249. I sure wasted a lot of money on law school if all it takes is a $249 course to be successful in court. But right above that, so they're asking for $2.9 billion in damages to themselves. And I was going to hide this until I got to it in the complaint, but I knew I'd forget this important fact. They're asking the court to make that $2.9 billion tax-free. When asked why he thought the court could waive taxes on that amount, Brunson replied, "We think the court has the power to do that." I mean, they think the courts have the power to do a lot of things, apparently, that the courts do not have power to do. So, with that, let's jump out of the Tribune for now. And this is the docket. Like I said, it's fairly short. It takes up a lot of real estate on the page, but that's because you look, these are all the defendants. All the defendants. You can pick your senator or pick your representative here. I noticed off the top of my head as I was scrolling, Jamie Raskin. There's let's see, Liz Cheney. There's Rob Portman from Ohio, Katie Porter from California. We've got Sheila Jackson Lee. I was looking for Mike Lee, but so Mike Lee, my senator, Debbie Wasserman Schultz, Maxine Waters. So all of these defendants in this case. Now, while they are defendants, they were unaware this was even happening. It was their offices received service by mail. It went straight to the U.S. Attorney's Office, who represented them all in one case. So scroll down, though, and it has a grand total of 34 items in the docket, and that includes the final order from the Supreme Court on January 9th. Spoiler alert, as I'm recording this at 11:14 p.m. on the 15th of January, so six days late after it was denied, as Joe Biden is still president, they failed. So I want to bring this up briefly. So I think I've mentioned before, my first summer internship during law school was at the U.S. Attorney's Office in Salt Lake City in the white collar crime division. But I interacted with a lot of the assistant U.S. attorneys from various different offices, well, different specialties, divisions, because I went to court a lot to observe. And so Magistrate Judge Jared Bennett, who decided the case in the district court, was the head of the civil division for the Utah U.S. Attorney's Office. Kind of he's an interesting guy, smart as a whip, a little awkward. Yeah. Jill Parrish was a judge at the time. I did my internship. I with her in her court a few times. But scrolling down, there's a couple of recusals, and one of them, well, let's find it. It was initially randomly assigned to Judge David Barlow, who was the U.S. attorney at the time of my internship. So head honcho. He's now a federal judge. It was then assigned to Magistrate Judge Cecilia Romero, who, before she became a judge, I dealt with her a few times as a lawyer at one of the bigger law firms here in Salt Lake. While I was in law school, but her husband was my state senator 10 years ago. So I spoke to both her and her husband quite a bit with political campaigns. So really good person. I believe she's one of the first, at least in Utah, she's one of very few, if not one of the first Native American federal judges. So, and then it was assigned to senior judge Bruce Jenkins, he's got to be near 90 now, but he's one of my best friends from law school. It's his grandpa's cousin. So just to illustrate what a small legal market we have here in Salt Lake. So let's jump over, though, to the U.S. Constitution, because it's just unfathomable to me that they filed this in state court, thinking Utah state court judges have the power somehow to remove a president or even to remove a U.S. representative or senator. I do not know how you get to that conclusion. But even federal judges, they can't, because we've got to look to the Constitution for how do you remove federal officials. And so Article 1 of the Constitution deals with the legislative branch. And Article 1, Section 5 is the rules of the House and Senate. And we'll wait for little mice in the hand to turn and load the internet. So to remove a representative or a senator, says each house may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3, expel a member. That's the only mechanism there is for removing a congressman. It's not a function of the judiciary to regulate Congress. Congress regulates Congress. And but then move to Article 2 of the Constitution, which details the presidency. And Article 2, Section 4 is impeachment, which We'll wait once again for it to very slowly load. It was a little faster this time. But the president, vice president, and all civil officers of the United States, which, since this is in Article 2, these civil officers would be in the executive branch, shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. And then for removing the president, there's also the 25th Amendment, which is removing the president either temporarily or permanently due to incapacity. So, once again, it's Congress removes presidents. Judges do not. I mean, you look back, Bush versus Gore in 2000 was extremely controversial because the Supreme Court said, oh yeah, we have the power to decide who wins elections. And Congress, at least Democrats in that case, said, hang on just a second, we have the power to decide who won the election. So, but I think even the Supreme Court wouldn't, they couldn't argue that they have the power to remove a president. And these civil officers of the United States, my constitutional law class was a long time ago, so I can't remember the exact analysis that goes into it, because some executive branch officials can be fired, some have to be impeached. And most of the cabinet, I believe, either has to resign or be impeached. I could be wrong. It's been a long time. But also the heads of some federal agencies that aren't cabinet positions, that's included there. So, funny enough, I don't think I'd have to search in the lawsuit. I don't think they've asked to remove the cabinet positions, so they would be in the line of succession, and Donald Trump would not. But with that, let's jump into the complaint, because I should have prefaced, this is going to be a long stream. I'm going to try to breeze through it as quickly as I can. I'm going to give analysis where it's needed. I'm not going to give as much as I have, like in the delete laws, Lolsuit. But this is amusing, at least from what I've seen. I've only skimmed through it. So here we have the summons, and which includes the complaint. So this is Rayland J. Brunson, who don't want his address up there, versus Alma Adams et al. Alma Adams being a member of Congress. And this is in the District Court of Utah, 2nd Judicial District, Weber County. That is Ogden, Utah, for those of you who don't know your Utah geography. It's 40 miles north of Salt Lake City. Initially, before Judge Camille Nieder, trial by jury demanded. The state of Utah to Vice President Kamala Harris, Vice President, via the Department of Justice, 950 Pennsylvania Avenue in Washington. You are hereby summoned and required to file an answer in writing to the attached complaint with the clerk of the above entitled court located at 2525 Grant Avenue, Ogden, Utah, and to serve upon or mail to plaintiff at their address a copy of said answer within 20 days after service of this summons upon you. If you fail to do so, judgment by default will be taken against you for the relief demanded in said complaint, which has been filed with the clerk of said court, and a copy of which is hereto annexed and herewith served upon you. dated and signed the 2nd day of July, 2021, signed by Rayland J. Brunson. Now, I wonder if this was dated and signed on the 2nd day of July as a symbolic gesture, because as most of you Americans at least would recognize, the Declaration of Independence, although we celebrate Independence Day on July 4th, the Declaration was signed on July 2nd. So I wonder if that's symbolic here. So here, though, we have the complaint. In the 2nd Judicial District Court, Weber County, State of Utah. Complaint. Rayland J. Brunson versus all of these people. Seriously, 3 pages for the caption, just for all of the defendants. Oh, including John and Jane Doe's 1 through 100. Yikes. Comes now. Plaintiff Rayland J. Brunson, in pro se, alleges against defendants as follows. Parties and jurisdiction. Plaintiff is an individual residing in Weber County, State of Utah. Plaintiff voted in the 2020 presidential election. The acts committed against plaintiff took place while he was living and voted in Salt Lake County, State of Utah. Plaintiff's right to bring this action includes, but not limited to, Amendment 1 of the United States Constitution, which states, Congress shall make no law respecting an establishment of religion Okay, I thought I'd make it farther. I thought I'd make it farther before I lost it. Plaintiff's right to bring this action includes, but not limited to, Amendment 1 of the United States Constitution, which states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably to assemble and to petition the government for a redress of grievances. Underline added. So this is a petition of the government for a redress of their grievances. You're petitioning the wrong branch. Defendants all have an office or workplace in Washington, D.C., excepting Michael Richard Pence, whose residency or place of work is currently unknown to plaintiff. I believe at that time, Mike Pence was still couch surfing in his post-vice presidency. This court has jurisdiction pursuant to Utah Code Annotated 78B 3-307. Let's look that up. Okay. Okay. Utah Code 78A. Let's find it. 78B 3-307. So let's go back. 78B. Three, actions and venue. Part 3. place of trial, venue. 307, all other actions. So, in all other cases, an action shall be tried in the county in which the cause of action arises, or any defendant resides at the commencement of the action. If the defendant is a corporation, any county in which the corporation has its principal office. If none of the defendants resides in this state, the action may be commenced and tried in any county designated by plaintiff. And the defendant, if defendant is about to depart from the state, the action may be tried in any county where any party resides. So this is ridiculous. They're claiming, well, they're saying this court has jurisdiction pursuant to Utah Code Annotated 78B 3-307. But this isn't jurisdiction. This is venue. This is venue. Venue is not jurisdiction. That's a simple concept. Venue is not jurisdiction. And even more egregious, though, so in what universe does a state court have jurisdiction to hear a federal question against the federal government? I mean, yeah, maybe if they sued in federal court, venue in Salt Lake City would be appropriate, but it's asinine. So, backdrop common to all allegations: the oath of office. Oh God, this is this is going to be pontificating, not litigating. Quote, let it simply be asked, where is the security for property, for reputation, for life, if the sense of moral and religious obligation desert the oaths which are the instruments of investigation in courts of justice? George Washington on the sanctity of oath. The oath of office is the thread by which today the U.S. Constitution hangs. The U.S. Constitution, Article 6, Clause 3 states, the senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. So I've actually taken that oath twice. I had to take that oath for my internship at the U.S. Attorney's Office. I also had to take that oath for my internship at the Securities and Exchange Commission, both federal agencies. The U.S. Senator defendants have each taken this oath. I do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely, without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter, so help me God. The U.S. House Representative defendants have each taken this oath as described in 5 U.S.C. Section 3331, which states, I, A.B., do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter, so help me God. Defendants have made an allegiance to God, which you'll remember, this is a pet peeve of mine in court too. Let's scroll up to Article 6, Clause 3, talking about oaths. But no religious test shall ever be required as a qualification to any office or public trust under the United States. But now here they're saying all of the defendants have made an allegiance to God that they would support and defend the Constitution of the United States of America against all enemies, foreign and domestic. The Constitution of the United States was established to protect our God-given rights, which are therefore unalienable. Every person on earth has these same rights. I think you'll find not every person on earth enjoys the rights of the United States. The second clause of the Declaration of Independence states, the Declaration of Independence is not a governing document, by the way. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. I told you this was going to be preaching, not litigating. Our unalienable rights are given to us from God, really preaching, and therefore no government has the power to make laws that deny or disparage them without being guilty of committing crimes against humanity. So no government has the power to make laws that deny or disparage them because our rights are given by. So why would the court have the power to negate my vote or your vote or whoever's vote? I mean, serious question. I'm sure almost every one of you in the United States who is a voter voted for at least one of these defendants, because they're all over the political spectrum. They're Republicans, Democrats, senators, House of Representatives, president, vice president, former vice president. So if you voted for Trump, you voted for Pence, and yeah. The Utah State Supreme Court supports the fact that our rights come from God, as found in the case of American Bush versus City of South Salt Lake from 2006, which states, in considering state constitutions, we must not commit the mistake of supposing that, because individual rights are guarded and protected by them, they must also be considered as owing their origin to them. These instruments measure the powers of the rulers, but they do not measure the rights of the governed. A state constitution is not the beginning of a community, nor the origin of private rights. It is not the fountain of law, nor the incipient state of government. It is not the cause, but the consequence of personal and political freedom. It grants no rights to the people, but is the creature of their power, the instrument of their convenience, designed for their protection and enjoyment of the rights and powers which they possessed before the Constitution was made. It is but the framework of the political government. It presupposes an organized society, law, order, property, personal freedom, a love of political liberty, and enough of cultivated intelligence to know how to guard it against the encroachments of tyranny. I saw nothing in there saying it's granted by God, but okay. Amendment 9 to the Constitution of the United States, known as the Interpretation Clause, clarifies the fact that no government has the right to misconstrue our God-given rights, which states, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Once again, these guys are preaching, my rights come from God, therefore Congress can't tell me what to do, but the court can force it on Congress. But once again, the Ninth Amendment says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So it basically, the first 8 of the Bill of Rights, the first 8 amendments said these rights are rights of the people. The people have the rights to freedom of speech, freedom of religion, freedom of the press, freedom of, right to bear arms. No, for all you Third Amendment auditors out there, the right to not be forced to quarter troops in a time of war. The right to remain silent. Those are rights. The Ninth Amendment says this isn't an exhaustive list of rights retained by the people. But then the 10th Amendment says, as long as it's not repugnant to the Constitution and it's not proscribed by federalism, as long as the federal government hasn't retained a certain power, then the states can make laws about it. So, but these brothers interpret the Ninth Amendment to say, in other words, Congress has no powers to enact laws that would violate our God-given rights. I find these kinds of arguments really annoying. Laws that violate our God-given rights are null and void. Consequences manifestly contradictory to common reason, they are, with regard to those collateral consequences, void. I lay down the rule with these restrictions, though I know it is generally laid down more largely, the acts of Parliament contrary to reason are void. But if the Parliament will positively enact a thing to be done which is unreasonable, I know of no power that can control it, and the examples usually alleged in support of this sense of the rule do none of them prove that where the main object of a statute is unreasonable, the judges are at liberty to reject it. For that were to set the judicial power above that of the legislature. For that were to set the judicial power above that of the legislature, which would be subversive of all government. But where some collateral matter arises out of the general words and happens to be unreasonable, the judges are in decency to conclude that this consequence was not foreseen by the Parliament, and therefore they are at liberty to expound the statute by equity and only quod hoc disregard it. Quoting State Ex Rel ZC, which is a Utah state case from 2007, which I think the brothers are misinterpreting this. It's Congress can pass laws. I believe what I'm reading from this quote is basically a description of rational basis analysis. Most laws are decided on a rational basis. Pulling to brain cramp here, but scrutiny. So rational basis is if there's any rational basis at all for a law to be passed, and there's constitutional ability for Congress to pass a law in that area, it's good law. It may be a bad rational basis, but if there's a rational basis, it's law. And then there's, intermediate scrutiny and strict scrutiny, where you have to have it narrowly tailored and I'm not going to try to remember, but my scrutiny analyses, because that just gets complicated. Powers put into place that fail to protect our God-given rights entitle mankind to, quote, dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them. A decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. First clause of the Declaration of Independence. So are you trying to secede? Because once again, you may not agree with the outcome of this election, but that's why we have elections. There are winners and there are losers. The exclusive powers extended to the legislative branch of Congress for the making of laws are subject to Amendment 9 of the U.S. Constitution, and as such, this Constitution and the laws of the United States which shall be made in pursuance thereof shall be the supreme law of the land. See Article 6 of the United States Constitution. And those federal election laws are the law of the land. So how can a state court overturn this? The defendants, by way of their oath of office, are sworn defenders of the U.S. Constitution. The defendants are sworn defenders of the U.S. Constitution, bound by oath to God to defend the God-given rights of we the people against foreign and domestic enemies of the U.S. Constitution. I wonder if this was what was taught in that $249 How to Win in Federal Court course. Because I guarantee my legal writing professor would be tearing her hair out at this. The U.S. Constitution was written with honor, respect, and recognition of our Lord Jesus Christ, as memorialized in Article 7, Clause 3, which states, in the year of our Lord. Which is how dates were written. Anno Domini, A.D. And as such, the defendants have sworn an allegiance to the author of our freedoms and liberties, our Lord Jesus Christ. Remember how we discussed the First Amendment and the oath, which said, shall make no oaths, no religious tests, no. This is so aggravating. I'm used to it living in Utah, but still. And more pontificating, because apparently the prophet Isaiah, chapter 30, verse 9 of the King James Version of the Holy Bible states that this is a rebellious people, lying children, children that will not hear the law of the Lord. The law of the Lord spoken by Isaiah is the U.S. Constitution as claimed by George Albert Smith. George Albert Smith being a prophet of a leader of the Mormon Church. This does not belong in any lawsuit. This is not Sunday school. This is not a worship service. This is not a Mormon sacrament meeting. This is court. This is elections. This is asinine. On September 23rd, 1945, George Albert Smith, a prophet of God of the Church of Jesus Christ of Latter-day Saints, quote, saints, while giving a dedicatory prayer of the Idaho Temple, stated, "For this purpose have I established the Constitution of this land, Doctrine and Covenants," that's one of the Mormon unique scriptures, chapter 101, verse 80, to fulfill the ancient prophecy of Isaiah that out of Zion shall go forth the law and the word of the Lord from Jerusalem. Isaiah chapter 2, verse 3. And as I said, the doctrine and the D&C is the Doctrine and Covenants of the Church of Jesus Christ of Latter-day Saints, the Mormon Church. The U.S. Constitution is the instrument set up by God to protect our God-given unalienable rights. I mean, I know I keep harping on this, but if you had a valid claim, this would not be a winning argument. Base it on the Constitution. Basing it on God, you might win some judges over. You're not going to win most judges over because they realize that the Constitution governs. The plenary power of Amendment 9 of the U.S. Constitution nullifies any kind of legal protection that an enemy against the U.S. Constitution claims to have. Okay. Let's go back to the Constitution. Ninth Amendment. I know we've quoted from the Ninth Amendment already. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. That's the entirety of the Ninth Amendment. That's the entirety of the Ninth Amendment that was quoted in its entirety a few paragraphs up. But the plenary power of Article 9 of the Constitution nullifies any kind of legal protection that an enemy against the U.S. Constitution claims to have. The plenary power of Amendment 9 nullifies any interpretation of Amendment 12 that would allow Congress to accept and count fraudulent votes provided by the states. A rigged election is an attack against the U.S. Constitution, especially against the Equal Protection Clause of the 14th Amendment of the U.S. Constitution. This is a case. So the Equal Protection Clause of the 14th Amendment is what's generally used. But basically, so your Fifth Amendment rights against self-incrimination. technically speaking, that's in federal court. But courts have interpreted the 14th Amendment due process clause, well, due process and equal protection. So, as saying, yeah, so that also applies in state courts. So, I wouldn't be using the equal protection clause of the 14th Amendment, I don't think. Yeah, I'm not a constitutional lawyer. I don't claim to be one. This seems wonky to me. But despite the showing of evidence proving that the November 3rd, 2020 U.S. presidential general election was fraudulent, what evidence? Affecting the President of the United States, the Vice President of the United States, and members of the United States Congress, the defendants intentionally refused to investigate the evidence and conspired to cover up the evidence to fraudulently have Joe Biden inaugurated as president and Kamala Harris inaugurated as vice president. But then wouldn't that mean that all of these, every one of the members of the House of Representatives and a third of the senators were also fraudulently elected? It was the same election. And alleging without evidence, it's just a conspiracy theory. This act of conspiracy has the same end result as an act of war, to place into power whom the defendants want, which is Biden. Fraud vitiates everything. I'm so sick of hearing that statement. Facts common to all the allegations. That's 6 or 7 pages of pontificating before we even get to facts. And you may see this is 102 pages for the complaint. I'm not going to read 102 pages. Most of that, thankfully, is exhibits. Facts common to all the allegations. Intentional refusal to ensure an honest and fair election. On January 6th, 2021, the 117th Congress held a proceeding and debate, which is attached, see Exhibit 1, which is attached, and is a copy of the congressional record of this proceeding and debate. The proceeding was for the purpose of counting votes for the President and Vice President of the United States under Amendment 12. The following took place in this proceeding. I seem to remember there was some sort of actual attack. I'm not imagining that, am I? At the top of this proceeding, the chaplain, Reverend, offered a prayer and in part stated, "We have pledged to defend our Constitution against all enemies. We pray your hedge of protection around this nation. Defend us from those adversaries, both foreign and domestic. So help us, God, to serve you and this nation with godliness and dignity. We pray these things in the strength of your holy name. Amen." Once again, how the hell is this relevant? I mean, I concede it happened during the hearing, but it's of no consequence. This is not a fact that has any bearing whatsoever on this case. So why take up 1, 2, 3, 4, 5 lines, 6 lines, because after this prayer, the Pledge of Allegiance was given. That's 6 lines wasted. Certain U.S. House representatives provided evidence exposing a fraudulent, rigged presidential election which was an attack against the U.S. Constitution. But that doesn't mean the rest of Congress has to accept that evidence. U.S. House Representative James Daniel Jordan, Jim Jordan, pointed out that there was something wrong with the presidential election when it was found that during the campaign, Biden would do an event and he would get 50 people to his event, while at just one rally, President Trump would get 50,000 people. But somehow Biden, who never left his house, wins the presidential election. Let's think back. What was happening during 2020? I seem to remember one party, especially in 2020, before the vaccines were out, stayed home. They weren't in large gatherings. Another party would throw parties. That doesn't show who's going to turn out to vote. But according to our plaintiff, that statement alone rings with enough circumstantial evidence warranting an investigation into the presidential election for voter and election fraud. But once again, even assuming this were a measure, you go to Alabama, you go to Mississippi, you go to Florida, you go to Utah, Idaho, you're going to fill a stadium. Should we compare events held in California? You know, for in a normal election year, it would be very different. Jordan asked defendants Chairman Nadler and Chairwoman Maloney for an investigation into the presidential election, who both refused. Because they're under no obligation to accept your evidence. Just like in court, a court is under no obligation to accept your facts as facts. Jordan stated that their refusal to allow any kind of hearing or investigation into the presidential election fraud was due to the fact that they wanted to ensure that President Trump would not win. This shows them as conspirators involved in an act of war against the U.S. Constitution. The presidential election was successfully uninvestigated, which disenfranchised the American voters. You're trying to disenfranchise I don't understand the cognitive dissonance here. The presidential election was intentionally not investigated by those involved on a large scale who had power to keep it from being investigated for any fraud or crimes, and who had the power to keep certain members, our judicial branch of government, from refusing to rule on the evidence of the fraud presented to them. That sentence makes no sense. The grammar is atrocious. And if I remember right, there were a lot of lawsuits before January 6th. They were dismissed. Congress did not interfere to force the dismissal. Jordan went on to identify acts connecting to and leading up to election and voter fraud by stating, on July 31st, 2016, Jim Comey's FBI takes out an insurance policy opens an investigation on the President Trump based on nothing. We're not, this isn't the 2016 election. An investigation based on nothing. Okay. And if I remember right, this investigation was kept under wraps until after the election, but certain other investigations were not, but okay. And then on May 17th, 2017, Mueller was named special counsel. Two years they investigate the Russia hoax. 19 lawyers, 40 agents, and $40 million of taxpayer money for nothing. And then on December 18th, 2019, Democrat House members voted to impeach President Trump based on an anonymous whistleblower with no firsthand knowledge who was biased against the president and who worked for Biden. My brain is going to break before I finish this. I mean, this is reading like your drunk uncle's Facebook rantings. And then, even after these attempts failed, they unconstitutionally changed the election laws of Arizona, Pennsylvania, Georgia, Michigan, Nevada, and Wisconsin. How? That's our old friend, once again, a conclusory statement. How were the changes to the election laws unconstitutional? Because I think you'll find election laws are allowed to be changed. They can be changed. I mean, after the 2020 election, when Georgia changed its election law to make it illegal to hand water to people standing in lines for the elections, was that an illegal change? When Texas changed its laws, making it much harder to vote, it was concerning the ballot drop boxes, the drive-up drop boxes. Well, clearly that one wasn't unconstitutional, since even though that was leading up to 2020, that's not in the unconstitutional changes. But the election laws that were changed in the said states violated the separation of powers doctrine, stealing the election from Trump for Biden's win. What? Newsflash. The states, with certain restrictions, have the power to decide how a state runs its elections. During the proceeding, U.S. House Representative Andrew S. Biggs produced 1,000 affidavits attesting to the rigged presidential election that gave Biden his win. That's still that's hearsay. That's hearsay. Why would Congress pay any heed? Also, Biggs identified more acts of a rigged election by laying before the proceeding a letter dated December 31st, 2020, addressed to Mike Pence from Kelly Townsend, whom at the time was a senator-elect, who attested in the letter that As the chairwoman of the Arizona House elections, so she was a state senator-elect. As the chairwoman of the Arizona House elections, she experienced several occurrences thwarting their ability to investigate election fraud surrounding the presidential election. And on December 14th, 2020, Arizona sent an alternate slate of electors, along with a resolution from 21 current and 8 newly elected legislators, asking defendant Pence to refrain from accepting the Biden electors until they could adequately investigate claims of fraud. How many bites of the apple do you get? I mean, honestly. And that she requested an election committee discovery hearing in order to invoke subpoena power to acquire the voting machines and ballots in order to do a comprehensive and forensic audit, which was denied. I mean, the Arizona Senate did seize the Maricopa County ballot machines. And she said that probable tampering with the voting machines existed, and that a group of Arizona citizens uncovered a minimum of over 100,000 fraudulent votes, supported by over 1,000 affidavits. And on December 9th, the Senate president authorized a hearing via the Judiciary Committee that did result in subpoenas to the Maricopa County supervisors who oversee the elections process that they had not yet, as of the date of her letter, been complied with, and they don't answer to the Senate president. She further stated that because they had been met with such strong obstruction at every turn, as itemized in Exhibit A of her letter, she moved Pence to not accept the electors until a resolution of the said matters had been made. The allegations found in Townsend's letter, including her Exhibit A, is incorporated as though her allegations are fully stated herein. During the proceeding, U.S. House Representative Morris Jackson Brooks, Mo Brooks, stated that for years the news media and the Democrats have deceived America about the Trump-Russia collusion and the existence of foreign interference in the 2016 elections. Okay. Mo, don't use first names. Brooks also stated that in 2020, Democrats promoted massive foreign interference in American elections by helping illegal aliens and other non-citizens vote in American elections, thereby canceling the votes and stealing elections from American citizens. Illegal aliens and non-citizens can't vote. I mean, if Democrats pushed for non-citizens who were eligible for citizenship to attain citizenship and then vote, that's not illegal. That's not a conspiracy. Brooks provided Exhibits A through J of compelling and irrefutable evidence that had only the lawful votes been cast by eligible American citizens been counted, Biden lost and President Trump won the Electoral College. More conclusory statements. The allegations made by Brooks, along with his said exhibits, are incorporated as though they are fully stated herein. You need to quote them I mean, you can reincorporate them like for your causes of action, but at least quote what you want in the lawsuit, in the facts. Moe stated it was his constitutional duty to promote honest and accurate elections by rejecting electoral college vote submissions from states whose electoral systems are so badly flawed as to render their vote submissions unreliable, untrustworthy, and unworthy of acceptance. It requires all members of U.S. Congress to do the same. But then you'd only accept electoral votes from those states that you like. Those are the ones that are reliable, trustworthy, and worthy of acceptance. The proceeding provides additional irrefutable evidence proving beyond a reasonable doubt that the presidential election was rigged in every single state of the United States of America, giving Biden and Harris a fraudulent win. Where is that evidence? You say it provided irrefutable evidence. Where is it? And no, conclusory statements. And yes, that includes conclusory statements made by Congressman Mo Brooks and Jim Jordan. Their conclusory statements are not evidence. The said fraudulent win was accomplished by, but not limited to, the illegal changing of both state and federal election laws. Laws can change. The counting of fraudulent illegal votes favoring Biden, wherein the number of submitted ballots exceeded the number of registered voters, and the voting machines fraudulently switched Trump votes to Biden. The rigged election was an act of stealing the election from legitimate, honest voters, which was protected by 1. The denial of investigations, 2. The corrupt mainstream news media, who almost on a daily basis discredited election and voter fraud allegations during relevant times, 3. By social media giants who discredited and silenced allegations of election and voter fraud, 4. By many members of the executive branch of government, such as state and federal prosecuting attorneys. 5. By members of the judicial branch of government, Article 3 courts. And 6. And by members of the legislative branches of government found in both state and federal levels. The protection was so widespread that it included all of the defendants who made wild claims that the election was honest, fair, and that there was no fraud of any kind affecting the outcome of the presidential election. The defendants conspired in giving aid and comfort to enemies of the U.S. Constitution. Despite the overwhelming preponderance of evidence presented throughout the proceeding, and found elsewhere that is readily available and continues to be exposed, all proving Biden's win was fraudulent, the defendants held fast to the lies that Biden won an honest election. So they say, despite the overwhelming preponderance of evidence. So that makes no sense. And here's why. So most civil cases are decided based upon a preponderance standard of evidence. So if you take if a jury says, all right, we're 50-50, that's a hung jury. If they say we're any degree above 50% for one side, they win. That's a preponderance. Now, overwhelming preponderance. What is an overwhelming preponderance? Because a preponderance is anything above 50%. So overwhelming evidence, that's a thing. But even still, so criminal cases have to be, they're the reasonable doubt standard. There's no reasonable doubts. That is a very high standard. Now, if the courts had the power to overturn a federal election, especially a presidential election, do you really think it would be a preponderance standard? I think, this is just me guessing, because, well, the courts don't have that power anyway. But so impeachment requires a 2/3 majority vote, I believe. It's either 2/3 or 70. Either way, it's more than 50-50. So I would think if the court even had this power, it would require clear and convincing evidence. That's the sort of intermediate standard. It's much harder to achieve than preponderance standard, but not as hard as reasonable doubt. But that's just my thoughts. The defendants pushed these lies with the cry that the presidential election was the most honest in history and that many courts of law agreed. Additionally, defendant Mike Lee stated, Mike Lee, senator for the state of Utah, where I live, and these plaintiffs live. Well, they live in the state of Delusion, but their physical presence is in the state of Utah. We each have to remember that we swore an oath to uphold, protect, and defend this document, written nearly 2.5 centuries ago by wise men raised up by God for that very purpose. That document makes clear what our role is and what it isn't. It makes clear who does what when it comes to deciding presidential elections. Then comes the 12th Amendment. Our job is to open and then count. Open, then count. That is it. That is all there is. I rarely agree with Mike Lee. And I do remember Mike Lee was on the fence as to what he'd do leading up to January 6th. But that is the job of Congress in this case. Then defendant Steny Hoyer stated, he's at the time was the number 2 or number 3 ranking member in the House of Representatives, if I remember right. We, the member of Congress who swore an oath before God to preserve and protect the Constitution of the United States and our democracy, must do so now. The defendants correctly espoused their duty under their oath of office, and then they knowingly mocked their oaths and the opening prayer by becoming the very enemies of the U.S. Constitution, which they swore to protect. The 12th Amendment cannot be construed to allow fraudulent votes to be counted. If so, then it stands in direct conflict with their oaths of office. Defendants cannot be sworn protectors and defenders of the U.S. Constitution and then be its enemy under the auspices of the 12th Amendment. This is treason! Furthermore, the 12th Amendment is not available for exercise under fraud. Okay. The defendants claim the U.S. Constitution was inspired by God, allowing a criminal to steal an election and then to be crowned its victor. Thou shalt not steal has no meaning to the defendants because they believe it was nullified by the 12th Amendment. They counted electoral votes. For the reasons stated above, the intentional disregard to investigate the presidential election for voter and election fraud was a levy of war and an attack against Brunson, the plaintiff's, constitutional right protected right to participate in an honest and fair election. First cause of action. Promissory estoppel, count 1, as to all defendants. Promissory estoppel is generally a contract term, concept, where if you promise to do something, the court can say, hey, or if you promise not to do something also, the court can say, hey, do or don't do that. You promised. It's essentially. That wasn't a very good description, but this isn't going to be a very well pled cause of action. So, plaintiff hereby incorporates all preceding and foregoing paragraphs, including all exhibits attached to this complaint, as though set forth fully herein. Promissory estoppel, count 1, failure to protect Brunson's right to vote in an honest and fair election. Each of the defendants have taken the required binding oath of office respective to their offices as either a U.S. Senator, U.S. House member, President, and Vice President of the United States. This oath is also a promise made to Brunson. Each of these defendants made a promise under their said oaths, which constitutes an oath to Brunson and to we the people, that they would ensure an honest and fair election. Article 4, Section 4 of the U.S. Constitution states, the United States shall guarantee to every state in this union a republican form of government. Voting is the greatest power an individual can exercise in a republic. It is their voice and the way citizens protect their constitutional rights and the U.S. Constitution. So, I'm not alleging these people are sovereign citizens, but so many of their claims in here are at least sovereign citizen adjacent. Because how many videos have we seen where sovereign citizens claim in court, you've got to provide me a republican form of government? There's one case in particular, I can't remember which one it is, but I think it's Michael Wayne Parsons, the Chilcotin ambassador. For those of you who don't laugh at sovereign citizens on YouTube, there's great videos of his, audio on YouTube of his court appearances. They're bad. An honest and fair election can only be supported by legal votes. This is sacred. It is the basis of our U.S. Republican form of government, protected by the U.S. Constitution. The efforts made, as stated above, that avoided an investigation of how Biden won the election is an act of treason and an act of levying war against the U.S. Constitution, which violated Brunson's right to vote in an honest and fair election, and as such, it wrongfully invalidated his vote. The defendant's refusal to investigate the serious allegation that the presidential election was rigged, as stated above, ran contrary to their oath to ensure an honest and fair election. Brunson relied upon the defendants for a fair and honest election when he cast his vote in the presidential election. During the proceeding, the votes of the electors affecting the presidential election that were presented for counting were cased with allegations of fraud as stated above. On account of this, all of the defendants were required by oath to protect Brunson's right to vote in an honest and fair election by rejecting the elector votes until an investigation had been made. This they did not do. By failing to do this, they wrongfully, unconstitutionally, and in violation of their oaths to Brunson, invalidated Brunson's vote. Failing to investigate how Biden won the election reaches the same effect as as though fraudulent votes had been counted to give him his win. This invalidated Brunson's vote so that he could not participate in honest and fair election. The said oath of office requires that defendants must fight against all enemies of the U.S. Constitution for Brunson and we the people. Furthermore, the 9th and 12th Amendments do not allow for the counting of fraudulent votes because in so doing it fails to protect the U.S. Constitution, thus protecting Brunson's right to vote in an honest and fair election. For the reasons stated herein, the intentional lack of investigation by defendants was an attack against Brunson's right to vote in an honest and fair election. Defendants' intentional lack of investigation into the allegations of election and voter fraud aided and abetted this fraud, and it violated Brunson's right to vote in an honest and fair election. The defendants all failed to protect the U.S. Constitution by thwarting the said investigation, which invalidated Brunson's vote. In this manner, they denied Brunson's right to vote in a fair and honest election, which also identified the defendants as enemies of the U.S. Constitution. As to defendants Biden, Pelosi, Harris, and Pence, in addition to violating their oaths by failing to protect Brunson's right to vote in an honest election, they also had direct ties ensuring that no said investigation would take place into how Biden won the election. This was done to ensure that Trump would not win, while also ensuring that they, except for Pence, would win their own elections, and also to invalidate Brunson's vote, thus setting a precedence that Brunson's vote would never be validated for any future federal or state elections. Oh, so he's suffering ongoing harm on and on and on forever. Second cause of action, promissory estoppel count 2 as to all defendants, because 1 count of promissory estoppel is insufficient. Plaintiff hereby incorporates blah, blah, blah. Promissory estoppel count 2, giving aid and comfort to enemies of Brunson's right to vote in an honest and fair election. How is this? Promissory estoppel is a contract provision, and it's my brain hurts. The defendants gave aid and comfort to the enemies of the U.S. Constitution, whose desire was to wrongfully invalidate Brunson's vote in violation of Brunson's right to have an honest and fair election. So, my question, serious question. And he says it's enemies of the U.S. Constitution that wanted Biden elected. But by the same measure, those American enemies of the Constitution would argue we were doing this to save the Constitution. And they'd argue Brunson is the real enemy to the Constitution. He's trying to throw out a fair election. The defendants had constructive knowledge of evidence proving that there was voter and election fraud. Mere allegations are not proof. They refuted this information and claimed that the election was transparent and honest, and as such invalidated Brunson's vote. As to defendants Biden, Pelosi, Harris, and Pence, in addition to violating their oaths by giving aid to enemies of Brunson's right to vote in an honest and fair election, they also had direct ties to ensuring that no said investigation would take place into how Biden won the election. This was done to ensure that Trump would not win, while also ensuring that they, except for Pence, would win their own elections, and also to invalidate Brunson's vote, thus setting a precedent that Brunson's vote would never be validated for any future federal or state elections. At least that one was much shorter. Third cause of action, breach of duty as to all defendants. Plaintiff hereby incorporates blah, blah, blah. As to the defendants' oath of office, they each had a duty to protect Brunson's right to vote in an honest and fair election. As stated above, the defendants were given plenty of evidence proving that Biden won a rigged election, which intentionally refused to investigate. Defendants had a duty under their oath of office to protect Brunson's right to vote in an honest and fair election by investigating the said claims that the election was rigged in favor of Biden. Defendants refused such an investigation, which invalidated Brunson's vote. Fourth cause of action, intentional infliction of emotional distress as to all the defendants. It is almost never intentional infliction of emotional distress. Plaintiff hereby incorporates all preceding blah, blah, blah. Each of the defendants took their oath of office without any mental reservations, knowing full well what it meant, with a strong will to never violate it. The prayer was a solemn witness to this. As stated above, the oath of office is also a promise to Brunson. The defendants, during the proceeding, gave a witness of their duty to keep their oath of office. The defendants, during the proceeding, purposely and maliciously violated their oath of office when they refused to conduct an investigation as to why Biden won the election. The refusal was a direct attack against Brunson's right to vote in an honest and fair election. It also gave aid and comfort to the enemies of the U.S. Constitution and was an act of treason by each of the defendants. Frankly, I'm shocked he's not asking for their executions for treason. The defendant's violation of the oath of office was a complete disregard to the votes of we the people and to Brunson's vote, along with his right to vote in an honest and fair election, causing extreme shock and distress to Brunson. The defendants who so easily violated Brunson's right to vote in an honest and fair election caused Brunson severe emotional damage. This damage causes fear that defendants are now on a course to violate Brunson's right to freely travel, to make a living, to have privacy, to own property, and essentially destroying his liberties. Brunson's daily emotional distress and suffering finds moments of relief when Brunson envisions that the defendants, especially Biden, Harris, Pelosi, Schumer, Schiff, Cortez, and Omar, will all soon be charged and found guilty of high treason. Oh, so apparently he is asking, or at least hoping, for that. And I notice he especially finds it the case for Adam Schiff, who led the House Oversight Committee, I think, but Cortez and Omar, noticeably women of color. Fifth section, fraud as to all the defendants. Plaintiff hereby incorporates blah, blah, blah. Defendants represented to Brunson that they would protect his vote and his voting rights pursuant to their oath of office. For the presidential election, Brunson cast his vote, which the defendants swore to protect, which they did not do. Before Brunson cast his vote, he knew that the proceeding would be by those individuals who would take or had taken the oath of office. Therefore, he was confident and feeling secure by their oath of office that his vote would be validated. The defendants who took their oath of office after Brunson cast his vote knew that Brunson would be relying upon them to validate his vote. The defendants induced Brunson to vote by way of their promises made to Brunson that his vote would be validated in an honest and fair election. They did this to give the appearance that the election was fair and honest, which they claimed during the proceeding. Brunson relied upon and was induced by defendants' promises, oath of office, to cast his vote for the presidential election. He did not know or even imagine that the defendants would not keep their promise. Brunson did not know that the defendants would fraudulently use a tactic to invalidate Brunson's vote by refusing to do any investigation into the allegations that the presidential election was rigged. This intentional act of fraudulently invalidated Brunson's vote. Defendants, during the proceeding, claimed that the presidential election was fair and honest, as though an investigation had produced this finding, when in fact no investigation had been done at all. Defendants wanted Brunson and we the people to believe this. The fact that the defendants fraudulently did not validate Brunson's vote in an honest and fair election deprived Brunson of his U.S. citizenship, because his vote is an essential element of his citizenship. And one, it inhibits his freedom of association for political groups, parity of resources among political groups to persuade. That sounds like an argument against gerrymandering. And two, it violates Brunson's right of purpose to listen to informed debates with equal opportunities to persuade. Voting is the greatest power an individual can exercise in this U.S. Republic. It is their voice and the way citizens protect their constitutional rights and the U.S. Constitution. Defendants, for the reasons stated herein, took this power away from Brunson. Defendants have damaged/violated Brunson of his sacred right and unalienable right to cast a vote in an honest and fair election. The number of damages defendants inflicted upon Brunson, as stated under this cause of action, is impossible to fully incorporate herein. Article 3, Section 3 of the United States Constitution states, treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. The defendants committed acts of treason and committed fraud against Brunson by denying his right to cast a vote in an honest and fair election. Biden and Harris both intentionally thwarted the said investigation, which constitutes that they ran a fraudulent campaign and as such aligned themselves as being enemies of the U.S. Constitution, and have committed acts of treason and committed fraud against Brunson by denying his right to cast a vote in an honest and fair election. Defendant Pelosi, with her direct ties to thwarting the said investigation, constitutes acts of treason and committed fraud against Brunson by denying his right to vote in an honest and fair election. Defendant Pence received a letter warning him that the presidential election had been rigged, and instead of pursuing an investigation into this warning, Pence participated in the proceeding, which was fraudulent for the lack of the said investigation, which means he committed acts of treason and committed fraud against Brunson, wrongfully invalidating Brunson's vote. Defendants defrauded the American people and Brunson of their right to vote in an honest and fair election by intentionally failing to allow the said investigation. As stated herein, defendant had full constructive knowledge of the said investigation should have taken place and outrageously refused. Pelosi and Pence, with their powers of seat, could have ensured the said investigation to take place. but instead they ensured the exact opposite and allowed the proceeding to take place, which fraudulently invalidated Brunson's vote. The defendants induced Brunson to vote with their promises that it would be validated. They falsely represented to Brunson by making the claim that his vote supported an honest and fair election for Biden's win, when in fact the defendants fraudulently invalidated Brunson's vote to give Biden his win. And as such, the defendants fraudulently and willfully damaged Brunson as stated herein. The defendants did this with full constructive knowledge. Sixth cause of action, civil conspiracy as to all the defendants. Plaintiff hereby incorporates blah, 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 blah. Each of the causes of action stated herein tie into this cause of action. Defendants all worked in concert, committing civil conspiracy during the proceeding, which identifies the date, where, and who was all involved. During the proceeding and as outlined above, all of the defendants were given constructive knowledge that the election was rigged. It was defendants' object. They were not given constructive knowledge. They were given allegations. It was the defendant's object and course of action to deny this knowledge in order to skirt any kind of investigation into whether or not the election was indeed rigged. As outlined above, it was unlawful for the defendants to have purposely refused any kind of an investigation into how Biden won the election. Defendants' unlawful refusal to have an investigation as to how Biden won the election constituted serious damage against Brunson. It also violated his vote, along with his right to vote and the free exercise of his citizenship, as explained above. Wherefore, plaintiff prays for relief against the defendants as follows, with any and all money damages to be tax-free. Because remember, he said, because we think the court has that power. Relief under the first cause of action. Defendants are to be removed from office with an order that they never be allowed to serve in any government office found anywhere in the United States of America, nor serve in the legal profession for the rest of their lives. Because the Utah State Court has the power to regulate the regulate lawyers in all other states, apparently. The Utah Supreme Court does have that power over me. That I practice under the authority of the Utah State Supreme Court. Defendants shall be forbidden to collect any further payments or retirements or income derived from the U.S. government for their services rendered to the U.S. government. Judgment against defendants shall incorporate the fact that each of the defendants failed to protect the U.S. Constitution, which invalidated Brunson's vote. Judgment against the defendants shall incorporate the fact that each of the defendants gave aid and comfort to the enemies of the U.S. Constitution, which invalidated Brunson's votes. Judgment against the defendants shall incorporate a recommendation that the defendants should be investigated for treason. Defendants, except for Biden, Pelosi, Harris, and Pence, shall each pay $1 million in United States legal tender money. As to defendants Pelosi, Biden, Harris, and Pence, they each shall pay $25 million in United States legal tender money. And it shall be ordered that former President Trump immediately be allowed to be inaugurated president of the USA. Relief under the second cause of action. Defendants are to be removed from office with an order that they are never to be allowed to serve, blah, blah, blah. Same same. $1 million again for everyone except Biden, Harris, Pelosi, Pence, because they all should pay $25 million. And print Trump as double president. I think we'll get a triple president. Relief under the third cause of action. Well, looky here. It's the same. And for the same amounts. And the fourth cause of action looks the same to me with the same amounts. Fifth cause of action, same. Sixth cause of action, the same. And for those who are mathematically challenged, which, that's 6 causes of action with 400, well, there's 535 senators and representatives total at 6 million each, but there are a few that aren't involved or weren't in office at the time. But then 6 times 100 million between these two, so that's 600 million. So that's tax-free $2,905 million. And for any such other relief that the court may deem proper. Dated this 21st day of June, 2021. Signed, Rayland J. Brunson, plaintiff. And then there's the exhibits. But I'm not going to go through the exhibits because I'm not insane yet. I might be by the end of this. So, like I said, they filed that in state court. It was very quickly removed to federal court. This is the notice of removal of state court action. Remember, if a lawsuit is inaccurately filed in state court, it's removed to federal court. If it's sent from federal court to state court, it's remanded. The defendant, federal officers, blah, 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 respectfully file this notice of removal pursuant to 28 U.S.C. Section 1442A1 and 1442A4. The grounds for removal of this entire action are as follows. On or about June 21st, 2021, plaintiff filed a civil action in state court in the 2nd Judicial District Court of Weber County, Utah, Ogden Department, State of Utah, claiming $2.905 billion in tax-free money and seeking the immediate removal from office of all of the named defendant federal officers and other relief against them, and also the immediate reinstatement of Donald J. Trump as President of the United States of America for an alleged violation of plaintiff's rights, in that he claims these defendant federal officers violated their oaths of office and waged war on this country and the unalienable God-given rights of its citizens by not further investigating claims that the 2020 presidential election was rigged and fraudulent, as plaintiff claims it was before these defendants accepted the electoral votes presented beginning on January 6th, 2021. This new state court action is one that may be removed pursuant to 28 U.S.C. 1442 as to all of the federal officers, and under 1442A4 as to the named members of Congress, in that it is a civil action commenced in a state court against federal officials for their alleged acts and omissions made under color of their federal offices. Defenses to the claims against these defendant federal officers include at least the following. A, lack of subject matter jurisdiction, as there is no waiver of federal sovereign immunity in any court for any of these 4 tort cases or causes of action claimed, and no waiver of such federal sovereign immunity for the two remaining promissory estoppel claims other than, at best, which is not conceded, the Court of Federal Claims, to the extent those promissory estoppel claims might be found to be proper claims sounding in contract, given that said estoppel claims each seek more than $10,000. The claims are all barred for plaintiff's lack of standing to pursue the claims. That's the one they're going to win on. The defendants, I mean. The claims are barred against all members of Congress and former Vice President Pence by the absolute immunity provided by the Speech or Debate Clause of the United States Constitution, Article 1, Section 6. The court lacks personal jurisdiction over all members of Congress named as defendants who are not elected from the state of Utah, and the claims fail to state a plausible claim for relief under the pleading standards outlined in Ashcroft versus Iqbal, our old friend that we have discussed many times in the DeCastro versus Abrams, the Delete Laws lawsuit, and its friend Twombly. This state court action is being removed within less than 30 days from the time the complaint was first served on the United States Attorney Office for the District of Utah, with a summons only addressed to Defendant Vice President Kamala Harris on July 16, 2021. Therefore, the removal of this proceeding has been timely effected. Pursuant to 1446A, attached hereto is a copy of the complaint as served on the United States Attorney's Office. The submission of this notice of removal is solely for the special purpose of removing this action to the appropriate federal court, and is not a general appearance for any of these removing defendants. This submission does not constitute a waiver of any defense available to any of these removing defendants under all applicable rules of civil procedure. Wherefore, notice is given that the entire above captioned action heretofore pending in the 2nd Judicial District Court of Weber County, Ogden Department, case number blah, 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 has been removed to this Honorable United States District Court. Dated 5th day of August, 2021. Signed, Andrea T. Martinez, Acting United States Attorney, and by John K. Mangum, Assistant United States Attorney. So, that was fun. But we still have the rest of the lawsuit. So, first and foremost, we have from the U.S. Attorney for Utah and John K. Mangum, the motion to dismiss for lack of jurisdiction and failure to state a claim for relief before the Honorable Cecilia M. Romero, Magistrate Judge in the District of Utah, Federal District Court. The 388 federal officers named as defendants, appearing specially through their undersigned counsel for lack of service on them, footnote 1, only the United States Attorney's Office was served with a summons for only Defendant Vice President Kamala Harris, with no service known on any of the individual federal officers themselves. Hereby move this honorable court to dismiss this action under Federal Rule of Civil Procedure 12b1 on the grounds that the court lacks subject matter jurisdiction, as plaintiff has not alleged any applicable waiver of federal sovereign immunity, and none is known for the matters alleged, including that plaintiff's claims are also barred by absolute legislative immunity. And 2, under Federal Rule of Civil Procedure 12b6, on the alternative ground that the complaint fails to state a claim for relief. Introduction. Plaintiff has filed his complaint in this state court against nearly 400 current or former federal officers, all in their official capacities. 291 members of the United States House of Representatives, 94 senators, and President Biden, Vice President Harris, and former Vice President Pence, citing the complaint caption, all 3 pages of it. And you'll notice, let's scroll back up. This is Rayland J. Brunson versus Alma S. Adams et al., meaning and others. When we get to the opposition to the motion to dismiss, you'll see he includes every last one of them in the caption yet again. That's a waste of real estate. The claims are based on plaintiffs' dissatisfaction with the outcome of the most recent election for president and vice president of this country, the United States of America, and plaintiffs' claims that defendants violated their oaths of office and waged war on this country and the unalienable God-given rights of its citizens by not further investigating claims that the presidential election was rigged and fraudulent, as plaintiff claims it was, before the defendants accepted the electoral votes presented beginning on January 6, 2021. See complaints all throughout. Plaintiff complains that this alleged failure to adequately investigate the election results has damaged him to the extent of $484 million for each of the 6 causes of action, for a supposed total, that's shade, a supposed total. That is wonderful shade, of $2.905 billion that he wants tax-free. He also seeks the immediate removal from office of all of the defendants, and that they never be able to collect any further pay from the United States for their official service in Congress or as president or vice president, that they never be able to again practice law or again serve as an elected officeholder in this country, that they each be investigated for treason, and that former President Trump be again immediately inaugurated as president. Plaintiff's first 2 causes of action are styled as claims for promissory estoppel. Once again, that's shade. They're styled as claims. He says they're claims for promissory estoppel. We don't take his word on that. Promissory estoppel is normally considered as sounding in contract rather than as a tort claim. Like I said, as a contract doctrine. That cites Heartland Biogas, I assume, LLC versus Board of City Commissioners of Weld City, from the District of Colorado in 2017. A promissory estoppel claim is properly characterized as one in the nature of a contract claim. Quoting Board of City Commissioners of Summit City versus Delusional, Colorado, 1996. Plaintiff's 3rd through 6th causes of action are all species of tort claims: breach of duty, intentional infliction of emotional distress, fraud, and civil conspiracy. Plaintiff's complaint is a virtually identical version of one earlier presented late last April by his brother Loy Arlen Brunson. That's the legal expert. As a proposed 3rd amended complaint, in case number blah, 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 in this United States District Court for the District of Utah, pending before Chief Judge Shelby and Magistrate Judge Romero of this court. So Chief Judge Shelby, Robert Shelby, a little tidbit for you guys. So the landmark Supreme Court case from 2015 that decided on the right to gay marriage in the United States is Obergefell versus Hodges, which came out of the 7th Circuit, I think. That's the one the Supreme Court decided. I walked out of, funny enough, my torts final exam, first semester of law school, December 15th or 20th or whatever, 2013. And we were all a little bit delirious. My classmate's girlfriend had her phone out and she was scrolling through and she says, "A court just made gay marriage legal in Utah." And we were all shocked. I mean, it was groundbreaking, and it was a case that even as law students we weren't filing because that case had no chance in Utah. But that was decided by, he wasn't chief judge at the time, but Judge Robert Shelby, who is quite the silver fox, and many of my classmates found him dishy. That case was, by the way, Kitchen versus Herbert, which was affirmed at the 10th Circuit, but was not decided at the Supreme Court level because Obergefell was instead. But the other case pending before Shelby and Romero, who thus far have unilaterally refused to accept that proposed complaint for filing or service, or to allow service of any prior version of the same proposed complaint filed by plaintiff Raylan's brother Loy Brunson. This court may take judicial notice of that other pending action. Quoting, "We may exercise our discretion to take judicial notice of publicly filed records in our courts and certain other courts concerning matters that bear directly upon the disposition of the case at hand." United States versus Hidley from the 10th Circuit in 2007. Standard of review. This is always important. Tell us, what standard of review? Well, generally, pro se pleadings should be liberally construed. Just the pleadings, remember from DeCastro versus Abrams, the pleadings have to be liberally construed from pro se plaintiffs. The procedure has to be followed. Court rules have to be followed. That's quoting Estelle versus Gamble from the Supreme Court in 1996. The Federal Rules of Civil Federal Rules of Civil Procedure, Rule 8E. That's our old friend Rule 8 that we've discussed in depth. Also, in the Delete Laws Lawsuit, how to plead. And C, Ogden versus San Juan County, 10th Circuit, 1994. The same jurisdictional, procedural, and factual standards for pleadings apply to pro se litigants. Well, hey, that's what I just said. See, also Ogden versus San Juan County. Courts should not advocate for litigants who elect to proceed without counsel. See Hall versus Bellman, 10th Circuit, 1991. The court need not allow leave for plaintiffs to amend their pleadings if it finds such amendments would be futile. Bradley versus Val Mejias, 10th Circuit, 2004. The burden to establish jurisdiction rests upon the party establishing that jurisdiction exists. See Cocoman versus Guardian Life Insurance Company of America, Supreme Court, 1994, and Montoya versus Chow, 10th Circuit, 2002. So, once again, in their complaint in the state court, they said, we have jurisdiction in this court because venue. Well, that's a non sequitur. That makes no sense. Argument. The complaint should be dismissed pursuant to Rule 12b1. this action cannot proceed without a valid waiver of sovereign immunity. There's a concept of sovereign immunity. So basically, in the US, you have dual sovereigns. You have the state as a sovereign, and the federal government as a sovereign. And then foreign countries are also sovereigns, obviously. So the Constitution has sovereign immunity, meaning you can't sue the sovereign. They have immunity. Well, in certain cases, the sovereign waives that immunity. But either there's a general waiver, or you have to ask for them to waive that immunity. So you have to say, please, government, can I sue you? And if they say no, then you're out of luck. And that's why judges can have absolute immunity in their judicial function. Congress has absolute immunity for their acts of Congress. But police officers, they're acting for the sovereign. They're given qualified immunity because the government recognizes police officers have power over life and limb out on the streets. So, sometimes they probably should be able to be sued, but not always. So it's qualified immunity. But this action cannot proceed without a valid waiver of sovereign immunity. The United States is a sovereign, and in order to bring a lawsuit against it or its agencies or officers sued in their official capacities, as these federal officers have been, a party must identify an express waiver of sovereign immunity and statutory authority granting subject matter jurisdiction. As a general rule, the United States, as a sovereign, is immune from suit, save as it consents to be sued. United States versus Mitchell, Supreme Court, 1980, quoting United States versus Sherwood, Supreme Court, 1941, stating, in general, federal agencies and officers acting in their official capacities are also shielded by sovereign immunity. And also quoting Merida Delgado versus Gonzalez, 10th Circuit, 2005, and citing Wyoming versus United States. So that's sovereign versus sovereign. So in some cases, I actually can't remember, because remember, the Supreme Court, for almost all cases, has they don't have original jurisdiction. They have appellate jurisdiction, and even then you have to go through the circuit courts, the mid-level appellate courts first, and it's even discretionary appellate jurisdiction. You've got to ask permission from the Supreme Court. But for the state of Utah to sue the state of Wyoming, sovereign suing sovereign, the Supreme Court has original jurisdiction. They hear that as a case of first impression. I can't remember if the same holds Wyoming versus United States. Well, I'm guessing it didn't in this case, since this is a 10th Circuit decision. So the United States consent to be sued is a prerequisite for jurisdiction. U.S. versus Mitchell, Supreme Court, 1983. In order for the United States to waive this sovereign immunity, the waiver cannot be implied, but must be unequivocally expressed. also Mitchell, quoting U.S. versus King from the Supreme Court in 1969. When the United States has not waived its sovereign immunity, the lawsuit must be dismissed. Flute versus U.S. 10th Circuit, 2015. Cert denied. October of 2016. Even if a lawsuit is brought pursuant to a statute in which the United States expressly waives its sovereign immunity, the suit must strictly comply with the terms of the statute, or else it is subject to dismissal. Citing Sherwood. So basically, if the U.S. says, well, we have sovereign immunity, but we waive it in this situation. Well, if they waive this situation, but you want to sue in this situation, nope. Brunson failed to establish compliance with any waiver of sovereign immunity for any of his claims. This court lacks subject matter jurisdiction over this action because Brunson failed to establish compliance with any waiver of sovereign immunity to sue these federal officials of the United States for damages or other relief. Brunson bears the burden of establishing a waiver of sovereign immunity and compliance with the conditions of any such waiver. His failure to establish such waivers or compliance with a waiver of sovereign immunity under each type of claim is shown below. I look forward to his reply. It's going to be a mess. No waiver for constitutional claims. Turning now to why plaintiffs' substantive claims cannot be heard or succeed in this court. First, the United States has not waived its sovereign immunity for it, its agencies, or employees in their official capacities to be sued for damages allegedly violating the Constitution. Citing FDIC versus Meyer, Supreme Court, 1994. The United States simply has not rendered itself liable for constitutional tort claims. Martinez versus Winner, 10th Circuit, 1985. I like that. Martinez versus Winner. I'm guessing Winner won. Holding that there was no waiver of sovereign immunity to bring constitutional claims against the Department of Justice or its employees sued in their official capacities. Therefore, Brunson fails to be able to allege any waiver of sovereign immunity as to his 9th or 14th Amendment bases for any claims he makes. No waiver for promissory estoppel claims. Second, Brunson's first two causes of action for alleged promissory estoppel are barred because he has not pled any basis for waiver of sovereign immunity for those claims. And even if plaintiff had a proper claim for alleged promissory estoppel claim, as does not appear here, then at best for plaintiff, which is not here conceded, only the United States Court of Federal Claims, and clearly not the state court or even this federal district court, might have jurisdiction to entertain such an action seeking more than $10,000 under the clear and express language of 28 U.S.C. 1346 sub A sub 2, excluding federal district courts from having jurisdiction over contract actions against the United States where more than $10,000 is sought, and 1491A1, granting the Court of Federal Claims jurisdiction over claims against the United States for cases, among others, upon an express or implied contract with the United States. Further authority for dismissing the promissory estoppel claims is here noted. See Coulibaly versus Kerry. I assume that's former Secretary of State John Kerry. That's just my guess. From the District of District of Columbia in 2016, further bolstering my thoughts that it's John Kerry, dismissing promissory estoppel claims against federal government employees, regardless whether claims sounded in contract or tort, and Orleans Parish Communications District versus FEMA from the Eastern District of Louisiana in 2011. I'm guessing that's Hurricane Katrina relief. See also Jablon versus United States, Ninth Circuit, 1981. Dismissing promissory estoppel claim against government, stating, "We have not discovered, and the parties have not cited, any precedent in this circuit for an independent cause of action against the government founded upon promissory estoppel. Neither have we discovered a statute which would allow Dr. Jablon to sue the United States in this instance." And number 3, no waiver for these tort claims. Third, there is no waiver of immunity for Brunson's tort claims, the 3rd through 6th causes of action. The only waiver of federal sovereign immunity for tort claims is under the Federal Tort Claims Act, FTCA, found at 28 U.S.C. sections 1346b1, 2671 to 2680. In re Franklin Savings Corp., 10th Circuit, 2004. The FTCA is a limited waiver of the United States sovereign immunity. The FTCA's waiver of immunity is limited to causes of action against the United States arising out of certain torts committed by federal employees acting within the scope of their employment. See U.S. versus Orleans, Supreme Court, 1976. Because the FTCA is only a limited waiver of the United States sovereign immunity, it is subject to a number of exceptions. See, e.g., 28 U.S.C. 1346b and 2680, Orleans, Supreme Court, once again. These exceptions are to be strictly observed, and exceptions thereto are not to be implied. Lehman versus Naction, Supreme Court, 1981, quoting Soriano versus United States, also in the Supreme Court in 1957. The FTCA does not allow such tort claims as are alleged here to be filed in state court, as they were, as Congress gave the federal district courts exclusive jurisdiction over such claims. 28 U.S.C. Section 1346b1, and see Richards versus United States in the Supreme Court of 1962. The Act permits claimants to sue only in the federal courts and not in the state courts, which are available in actions against a private individual, citing Section 1346b. Removal of the state court action to this federal district court under Section 1442 does not cure that problem under the doctrine of derivative jurisdiction. I don't remember if we studied derivative jurisdiction or not in civil procedure. It is well settled that if the state court lacks jurisdiction over the subject matter of the parties, the federal court acquires none upon removal, even though the federal court would have had jurisdiction if the suit had originated there. It is well settled that if the state court lacks jurisdiction over the subject matter or the parties, the federal court acquires none upon removal, even though the federal court would have had jurisdiction if the suit had originated there. Okay, so if you had filed in federal court and federal court had jurisdiction, they can hear it. If you file in state court and state court can never have jurisdiction to hear it, even though it's removed to federal court doesn't have jurisdiction. Whereas if you file in state court a claim that the state court could hear, but it's removed to federal court, like under diversity jurisdiction, federal court has jurisdiction. That's my reading of this. So, and that's Arizona versus Manny-Penny, heard in the U.S. Supreme Court in 1981. Even though Congress later changed this for removals under Section 1441, the doctrine split still applies for removals under Section 1442, the section under which the removal in this action was made. See Bowers versus J&M Discount Towing, LLC, District of New Mexico, 2006. Next, only the United States, and not its officers, such as these federal officer defendants, can be sued under the FTCA. That's 28 U.S.C. Section 2679 A and B. And citing Smith versus United States, 10th Circuit, 2009. Next, Brunson cannot pursue his tort claims because the FTCA does not waive sovereign immunity where there is a failure to exhaust administrative remedies before filing suit. To invoke the FTCA's limited waiver of sovereign immunity, Congress requires each plaintiff to first present the claim to the agency whose employees allegedly committed the negligent or wrongful act and wait 6 months for the agency to act before filing suit. 28 U.S.C. 2675A. Accordingly, failure to exhaust administrative remedies precludes a court from exercising subject matter jurisdiction over any alleged tort claim. See McNeil versus United States, Supreme Court, 1993. The FTCA bars claimants from bringing suit in federal court until they have exhausted their administrative remedies. Because petitioner failed to heed that clear statutory command, the district court properly dismissed his suit. Lopez versus United States, 10th Circuit, 2016. Brunson entirely failed to present to the federal courts an administrative claim for his alleged injuries, and he does not allege that he did so. Even if he had, he manifestly did not wait the required 6 months before filing suit. Other authority showing that the tort claims lack jurisdiction for his failure to exhaust administratively are here noted. See Sonnen versus New York State Department of Health, 2nd Circuit, 2013, action against senator arising out of a constituent service, Kiter versus McCain, 9th Circuit, 2006, affirming FTCA dismissal for failure to exhaust an action against senator for allegedly conspiring against the plaintiff, Bronner versus Education Management Corp, 2012, Eastern District of Pennsylvania in 2012. This is some bad formatting. They've got this as a hyperlink, this whole thing. Stating in dismissing action against senator that nothing in the complaint or in plaintiff's responsive briefs read in the light most favorable to him suggests that he took steps to exhaust his administrative remedies before filing a suit in federal court, which was affirmed in the 3rd Circuit in 2013. DeMassey versus Schumer, SDNY, 2009. Same failure to exhaust, or same failure to allege exhaustion. While plaintiff's failure to allege exhaustion of his FTCA administrative remedies is dispositive, the Office of the Senate Sergeant at Arms, which is charged with processing administrative tort claims filed with the Senate under the Act, see Senate Resolution 492, 97th Congress, 1982, reprinted in Senate Manual, Senate Doc number 116, 2020, available on govinfo.gov, has confirmed that it has no record of any claim submitted by the plaintiff. Therefore, Brunson cannot invoke the FTCA's limited waiver of sovereign immunity, which requires dismissal of his 4 tort claims for lack of subject matter jurisdiction. 4. No standing. This is the one they decided on. Finally, Brunson lacks Article 3 standing because his generalized claims of legislative nonfeasance arising out of the counting of electors' votes do not establish injury in fact. See Lance versus Kaufman, Supreme Court 2007, dismissing for lack of Article 3 injury in fact voters' challenge to redistricting plan and reaffirming the court's lengthy pedigree of actions holding that a plaintiff raising only a generally available grievance about government, meaning one that anyone can bring, but isn't particularized harm to them, claiming only harm to his and every citizen's interest in proper application of the Constitution and laws, and seeking relief that no more directly and tangibly benefits him than it does the public at large, does not state a claim, does not state an Article 3 case or controversy. Cogswell versus U.S. Senate, 10th Circuit, 2009, affirming dismissal of generalized grievance alleging unconstitutional Senate delay in filing 2 district court vacancies, or filling 2 district court vacancies. And Reiser versus Daschle, 10th Circuit, 2002, affirming dismissal of challenge to Senate's rule referring judicial nominations to Judiciary Committee, holding that pendency of plaintiffs' other cases and claims of alleged delay because of vacancies in the courts do not establish an injury. And Urias versus Obama in the 9th Circuit from 2016, affirming dismissal of complaint against senator for plaintiff's lack of particularized injury in suit alleging various claims arising from defendant's alleged failure to act in accordance with the United States Constitution. DeGenis versus Murphy, 3rd Circuit, 2008, affirmed dismissal for lack of Article 3 injury for Congressman's failure to take official action plaintiff requested. Seriously, can you please do this? No. I'm suing. Cates versus United States, District of New Jersey, October 2019, dismissing for lack of injury and, in fact, action against federal executive, legislative, and judicial defendants for alleged oath of office violations. Plaintiff lacks Article 3 standing for the additional reason that the injury he alleges may not be redressed by the equitable relief he seeks. Remember, money damages are law. Equitable damages are, or equitable remedies are do this. Law remedies are pay this money. So the equitable relief he seeks is make Trump president and get rid of the rest of the government. Courts, for example, lack the power to remove members of Congress from office, to disqualify them from holding future office, or to investigate matters before them. Remember, we looked at Article 1, Section 5 of the Constitution way back 2.5 hours ago at the start of this video. It's also in Roudbush versus Hartkey, Supreme Court, 1972, recognizing that who is entitled to the office of senator is an unconditional and final judgment exercised by the Senate alone, citing Senate's constitutional power to judge elections. And Berry versus United States, ex rel. Cunningham, Supreme Court, 1929. Senate power to judge the elections of its members authorizes it to render a judgment which is beyond the authority of any other tribunal to review. Only the Senate gets to decide Senate rules. Wright versus Brady, Southern District of Texas in 2006, this court has no authority to order a sitting congressman removed from Congress because only Congress, only the House of Representatives has that power for the House of Representatives. See also Kelly versus Wall, District of Rhode Island, 2010. It is not within the purview of the courts to order Congress to undertake an investigation, adopting recommendation from another case in 2010. So, I would have proceeded, although this one, Raudebush, might be about the Senate. Wait, no. Up here. Yeah. I would have included only Congress has the power to remove the president and vice president through impeachment, not the courts. C. Brunson's claims are also barred by absolute legislative immunity. As all of Brunson's claims against the defendant members of Congress and former Vice President Pence, remember, he's the president of the Senate as vice president, concern their accepting the Electoral College votes during one of the most important functions of Congress, mandated by the 12th Amendment, without doing further investigation of specious fraud claims never proven to the satisfaction of dozens of courts. These causes of action are also barred by the doctrine of absolute legislative immunity under the speech or debate clause of the Constitution found in Article 1, Section 6. So, really, if you want to defame someone, become a senator and then defame them on the Senate floor, because you have absolute immunity for anything you say on the Senate floor as a senator. It there states, the senators and representatives, for any speech or debate in either house, shall not be questioned in any other place. And by question, that means have to defend themselves in court. This clause affords members of Congress an absolute immunity from all claims arising out of their conduct in the legislative sphere. See USC 28 USC 2674, preserving legislative immunity as a defense in FTC actions, and see McCarthy versus Pelosi, DC Circuit 2021. The Supreme Court has consistently read the speech or debate clause broadly to achieve its purposes. And once again, quoting Rangel, which was quoting Eastland versus U.S. Servicemen's Fund, Supreme Court, 1975. The clause applies not just to speech and debate in the literal sense, but to all legislative acts. So they have immunity from consequences other than from Congress itself for investigations of Congress or for non-investigations of Congress, because non-investigation is a legislative act. That's McCarthy again, and citing Doe versus McMillan, Supreme Court, 1973. The power of the Congress to conduct investigations is inherent in the legislative process. Watkins versus United States, Supreme Court, 1957. Speech or debate immunity thus bars claims about the use or lack of use of that power. See Rockefeller versus Bingaman, 10th Circuit, 2007. Cert denied, also in 2007. Holding that speech or debate immunity barred suit challenging the decision of individual congressmen not to take legislative action in response to plaintiff's prompts. Peterson versus Hatch, 10th Circuit, 1996. The essence of the complaint in this case is that appellant disagrees with Senator Hatch's legislative judgment. Side note, this hearing, the federal district court in Utah is the Orrin Hatch Federal Courthouse. That's Senator Hatch here. The speech and debate clause precludes judicial re-examination of those legislative policy choices. Voint versus Fine, 5th Circuit, 2008, speech or debate immunity barred suit against congressmen for their alleged failure to investigate his claims. Ray versus U.S. Senate, 4th Circuit, 1989, holding speech or debate clause barred suit, stating plaintiff cannot claim damages for a committee's or a senator's failure to act on her behalf. Shaker versus Feinstein, Central District of California, 2017, dismissing on speech or debate grounds frivolous suit against Senator Feinstein to compel her to investigate. Thus, the speech or debate clause also bars Brunson's claims. Personal jurisdiction is lacking over Congress members not elected from Utah. Plaintiff's complaint, insofar as it makes claims against members of Congress not elected from Utah, is also subject to dismissal for lack of personal jurisdiction over those defendants because the complaint fails to allege the requisite minimum contacts with the forum state to subject them to suit in the state. See Liberation News Services versus Eastland, 2nd Circuit, 1970. Affirming dismissal of suit against United States senators for lack of personal jurisdiction, and Subramanian that versus Beale, District of Oregon, 2013, dismissal for lack of personal jurisdiction of action against former senator for conduct arising out of the performance of official duties. Wade versus Alaska, Southern District of Texas, in 2012, recommending dismissal for lack of personal jurisdiction for action alleging that senators not elected from forum state failed to take action in response to plaintiff's request, adopted by the Southern District of Texas in 2012. Alternatively, so remember, we've discussed this before. Alternative pleading is where you say, we think this should be decided on this. But, even if you don't agree with it there, we also think it should be decided on this. And even if these are contradictory, we're pleading in the alternative. Pick one you like. If one works for us, great. So, alternatively, Brunson failed to state a claim for relief. So, what they're saying here is, well, there's no jurisdiction, so you've got to dismiss for that. But if you think there is jurisdiction, which there isn't, you've got to dismiss for failure to state a claim upon which relief can be granted, 12b-6. So, in considering 12b-6 motions, the court starts by examining the complaint. To survive a motion to dismiss, a complaint must contain sufficient factual matter, which, if accepted as true, to state a claim that is plausible on its face. Citing Burnett versus Mortgage Electronic Registration Systems, Inc., 10th Circuit, 2013. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Also Burnett. The court must accept all the well-pleaded allegations of the complaint as true and must construe them in the light most favorable to the plaintiff. Albers versus Board of City Commissioners, 10th Circuit, 2014. See also Garcia Rodriguez versus Gom, District of Utah, 2016. That said, A court is not required to accept as true conclusory statements or legal conclusions couched as factual allegations. There's our old friend again. Conclusory statements. The complaint was it was page upon page of conclusory statements. And that is citing our old friend Ashcroft versus Iqbal from the Supreme Court in 2009, which quoted Bell Atlantic versus Twombly, also our old friend, also from the Supreme Court in 2007. A pleading that offers labels and conclusions or a formulaic recitation of the elements of a cause of action will not do. A court must draw on its judicial experience and common sense to determine whether a complaint states a plausible claim for relief. Also, Iqbal. See also, though, Warnick versus Cooley, 10th Circuit, 2018. Here, the plausibility requirement of Rule 8, remember our old friend, Civil Procedure, Rule 8, that's the pleading standards, has not been met. Just because a few members of Congress may have claimed there were improprieties with the election or that further investigation was proper, there was no duty for other members of Congress to agree, and plaintiff has not adequately alleged a proper basis for further investigation to have been required before defendants accepted the electoral votes properly presented. Claims that cannot state a proper basis for relief are subject to dismissal with prejudice under Rule 12b-6 for failure to state a proper claim for relief. The claims presented by plaintiff are implausible by their very nature, and the billions of dollars demanded and the other relief sought show how frivolous the claims of Mr. Brunson are, notwithstanding that he may sincerely believe that the presidential election was somehow rigged. Further, a court is not required to review all. I had a blip with my internet there. That's why I paused. But like all those Brunson attached to his complaint, 75 pages. Yeah. In an effort to address deficiencies in the complaint and identify facts to support a plaintiff's legal theories. So that's what I said. If you want it in the lawsuit, put it in the complaint. Don't attach 70 pages and say, well, this is all incorporated. So if you don't think I've stated a claim, go find it in this 70 pages of extra bullshit and, see if you can make a claim out of that. That doesn't work. So says Rusk versus University of Utah Healthcare Risk Management, Utah Court of Appeals, 2016. No court, to our knowledge, has ever recognized a cause of action against a member of Congress for the alleged failure to take legislative action to a constituent's satisfaction. See Apple versus Glenn, 6th Circuit, 1999. I assume that's former astronaut and former Senator John Glenn. Affirming sua sponte means on the court's motion, on the court's prerogative, dismissal for lack of subject matter jurisdiction of action based on implausibility of First Amendment claims against United States Senator and other top government officials for their alleged failure both to respond and to take action in response to plaintiffs' requests. I assume their complaint that in that case they were complaining, it's my First Amendment right to petition my government for redress of my grievances, and thus if you don't take up that petition, you've wronged me. And then, also quoting Newell versus Brown, Sixth Circuit, 1992, upholding dismissal of a claim against a congressman arising out of service to a constituent, stating, for the federal judiciary to subject members of Congress to liability for simply doing their jobs would be unthinkable, because it would violate the separation of powers doctrine. Richards versus Harper, Ninth Circuit, 1988, holding that a congressman's failure to assist a constituent was neither inappropriate nor actionable. Davis Court versus Claybrook, Western District of Washington, 2019, dismissing claims that Senate staffer failed to investigate the IRS alleged wrongdoing. Ninth Circuit, 2020. And D'Amato versus Rell, District of Connecticut, 2010. The refusal of a member of Congress to assist a constituent does not constitute a cognizable claim. And Lanick versus Biden, District of Delaware, 2007, so from when he was Senator Biden, recognized the same. Accordingly, Brunson's complaint is also and alternatively subject to dismissal with prejudice for failure to state a cognizable claim. Conclusion. For all of the reasons noted above, this action should be dismissed without prejudice for lack of subject matter jurisdiction and personal jurisdiction, or alternatively dismissed with prejudice for failure to state a claim. Submitted August 2021 by Andrea Martinez and John Mangum from the U.S. Attorney's Office. And that was a very, very well-written motion, which is unsurprising because taking a look, Andrea Martinez, the Utah bar, generally, you can take the bar number, hers being 9313, she was most likely admitted to practice in the state of Utah in the year 1993. John Mangum, this actually is a bit surprising, was admitted probably in the year 2020. That doesn't mean, though, that he's only been practicing since 2020, because he could have been practicing elsewhere and then applied for admission or taken the Utah bar well into his career. Although this is such a frivolous case that they could have gone with a first-year attorney. I mean, you've got to be top-notch to be at the U.S. Attorney's Office anyway. So they very well could have gone with a first year. Either way, that was very well written. I have a feeling that Rayland J. Brunson, in his opposition to motion to dismiss for lack of jurisdiction and failure to state a claim for relief, I have a feeling this is going to be more difficult. Plaintiff, Rayland J. Brunson. Oh, and in this one, he actually did only, the caption is shorter, Brunson versus Alma Adams et al., instead of the whole list of defendants. Plaintiff, Rayland J. Brunson. Oh, and this is same time period. The appeal is much later, a year later. Brunson hereby moves this court with his opposition to motion to dismiss for lack of jurisdiction and failure to state a claim for relief, and states, as the Supreme Court explained in Bell Atlantic Corp versus Twombly, Plaintiff's complaint need not contain detailed factual allegations, but it must plead enough facts to state a claim for relief that is plausible on its face. Twombly. And those allegations must be sufficient to create more than a speculative right to relief. A claim is plausible on its face when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Twombly. Here, plaintiff must be required to frame a complaint with enough factual matter to show that he is entitled to relief against defendant and to nudge his claims across the line from conceivable to plausible, citing Iqbal. Notice, he says he has to have enough factual matter. But once again, look back to the motion to dismiss. Factual matter does not include conclusory statements. You actually have to bring the facts. The policy behind this plausibility standard is to expose defects in a case early in the process, at the point of minimum expenditure of time and money by the parties and the court. A Rule 12b6 motion to dismiss admits the facts admits the facts alleged in the complaint, but challenges the plaintiff's right to relief based upon those facts. Quoting St. Benedict's Development Co. versus St. Benedict's Hospital. I do not like the way these are cited, just because it's hard to read. But that's I'm guessing that's Federal District of Utah in 1991, because it's in the Pacific Reporter, second edition. So that looks like a federal citation, 811 P. 2nd 194. But Utah 1991. That needs to be cited District of Utah. But citing 61 Amjur 2nd pleading section 227 1981. Who cares what Amjur has to say? Rule 12b6 concerns the sufficiency of the pleadings, not the underlying merits of a particular case. Alvarez versus Galetka. Once again, I think District of Utah, 1997. And does not serve to establish the facts or resolve the merits of the case. Whipple versus American Fork Irrigation Company. Once again, I think District of Utah, 1996. And Whipple is a plumber service here in Utah that I would not recommend using. The sufficiency of a complaint must be determined by the facts pleaded rather than the conclusions stated. Franco versus Mormon Church. Yeah, I think that's a state court, because this looks like a citation form that for state court cases within the state of Utah, but you only cite that form in Utah state courts. And here, I mean, this citation doesn't help, though. The sufficiency of a complaint must be determined by the facts pleaded rather than the conclusions stated. His complaint is nothing but conclusions. Subject matter jurisdiction. Defendants argue that this court does not have subject matter jurisdiction, which is misplaced at best based upon two doctrines. One, fraud vitiates everything it touches. It doesn't grant jurisdiction to a court that wouldn't otherwise have jurisdiction. And two, administrative functions are not protected by any kind of governmental immunity. Where the hell do you get that? Where? And how, even if there is no governmental immunity, it doesn't grant the court's jurisdiction to decide for Congress how Congress should act in Congress. That's for Congress. Our courts have consistently held that fraud vitiates whatever it touches. Morris versus House. It is 32 Texas 492. Is that a Texas Supreme Court case from 1870? And the estate of Stonecipher versus estate of Butts. What? 591 SW 2nd 806. What court is that even? You've got to tell us. And it is a stern but just maxim of law that fraud vitiates everything into which it enters. Veterans Service Club versus Sweeney. Once again, is this Federal District Court of Kentucky or is this Kentucky Supreme Court? I don't know. And Radio Shack versus ComSmart Inc., which fails to give any indication of a court. Vitiate means to impair or make void, to destroy or annul, either completely or partially, the force and effect of an act or instrument. West's Encyclopedia of American Law, Edition 2. Brunson's fifth cause of action against defendants is for fraud. And paragraph 34 of Brunson's complaint alleges that fraud vitiates everything. Defendants, under their sworn duty, promised that they would protect Brunson's vote in the 2020 presidential election, which they fraudulently did not do, as alleged in the complaint. I mean, here's the nonsense. This once again, it's conclusory, but it's also a non sequitur. It does not make sense because he says, well, this court has jurisdiction because fraud vitiates everything, and therefore you have jurisdiction. So it's circular, but it's like, well, my cause of action is for fraud. Therefore, since fraud vitiates everything, you have jurisdiction because I've alleged it. But in order for fraud to vitiate anything, you've got to prove fraud. And how has he proved fraud? Conclusory statements vitiate nothing. On January 6th, 2021, the 117th Congress held a proceeding and debate. This proceeding was for the purpose of counting votes for the President and Vice President of the United States under Amendment 12 of the Constitution. The complaint alleges that during the proceeding there was, from certain members of Congress, a strong plea to investigate the election. This proceeding, including this plea to investigate the election, was witnessed by the entire nation because there were claims of fraud, which included claims of over 100 affidavits detailing that the election was rigged with fraud and claims that there was massive foreign interference in the election by helping illegal aliens and other non-citizens vote in the election, thereby canceling the votes. The defendant's intentional act to vote against this plea to investigate these claims of fraud threatened the election from every single legal vote cast in the election. The complaint alleges that defendant voted against investigating these serious claims of a rigged election. Defendants voted against the investigation and against investigating the claims that there are over 1,000 affidavits claiming voter fraud, and against investigating the claim that there was massive foreign interference in the election by helping illegal aliens and non-citizens to vote, thereby canceling the legal votes. And defendants voted against investigating claims made by the mainstream news media, who at relevant times, almost on a daily basis, discredited voter fraud allegations. And defendants voted against investigating the social media giants who discredited and silenced allegations of election and voter fraud. And defendants voted against investigating many members of the executive branch of government, including state and federal prosecuting attorneys who allegedly covered up voter fraud. And the defendants voted against investigating members of the judicial branch of government, Article 3 courts who allegedly covered up voter fraud. The defendants voted against investigating all the allegations from many sources across this country in order to determine whether or not the election was fair and that there were no criminal actions involved in the election affecting the outcome of the presidential election. Defendant Steny Hoyer stated, "We, the member of Congress who swore an oath before God to preserve and protect the Constitution of the United States and our democracy, must do now." The said serious allegation required defendants. Where does he get that they're required to believe any and all bullshit? Seriously. But to investigate the allegations under their sworn duty to protect Brunson's right vote, along with every single legal voter that voted in the election. If there is ever a case where there is an enemy to the Constitution, whether it be foreign or abroad, the only way to determine if it is a threat, it must be investigated. Members of Congress who did cry out for an investigation into whether or not there is an enemy attacking the Constitution requires the action of every oath-bearing member of Congress to execute their duty by conducting such investigation. I mean, if they think there's a problem, their duty would be to convince the others to investigate. It's not the others' duty to believe them. They can say, "We think you're full of it. Go sit down. We're ready to vote." The proceeding provides proof that there were members of Congress claiming that the presidential election was rigged in every single state of the United States of America, giving Biden and Harris a fraudulent win. In the proceeding, certain members of Congress claimed that the said fraudulent win was accomplished by, but not limited to, the illegal changing of both state and federal election laws, the counting of fraudulent illegal votes favoring Biden, wherein the number of submitted ballots exceeded the number of registered voters, and the voting machines fraudulently switched Trump votes to Biden. He's just rehashing his complaint here. This isn't an amended complaint. This is opposition to a motion to dismiss. You'd be better served responding to their motion. Say, you have jurisdiction because of this. This survives 12b-6 because this. Defendants' voluntary sworn duty, as alleged in the complaint, is paramount and guards defendants from committing any abuse of this duty by exposing them to consequences when they commit fraud. Their acts of fraud, as alleged in the complaint, vitiates their claim of any kind of immunity. Citation fucking needed. What happened during the proceeding was the intentional act of defendants discrediting these claims of voter fraud without an investigation proving otherwise. And as such, the 12th Amendment cannot be construed to allow the discrediting of claims of voter fraud. Otherwise, it stands in direct conflict with their oaths of office. Wouldn't it be their oaths of office conflict with the 12th Amendment? You can't complain. Well, the 12th Amendment, which is part of the Constitution, conflicts with their oath of office. So the 12th Amendment's out the door. Defendants cannot be sworn protectors and defenders of the U.S. Constitution and then be its enemy by discrediting claims of voter fraud as stated above. Otherwise, they would be giving aid and comfort to the enemies of the United States Constitution. Furthermore, the 12th Amendment is not available for exercise under any acts of fraud. So what took place was not a 12th Amendment procedure. Rather, it was an administrative act to complete a possible rigged election. Defendants' vote against investigating the election aided and abetted an enemy at the gate: election fraud. It is not in the capacity of any of the defendants to vote against investigating the claims of a rigged election, and as such, they are not protected under any claims of immunity. The complaint alleges that defendants' vote to not investigate the claims of voter fraud during the proceeding turned the 12th Amendment proceeding into an administrative act to where they committed their fraud. Again, a 12th Amendment proceeding is not available under acts of fraud. Where the hell is he getting this? I mean, seriously. Governmental administrative acts are not afforded immunity. Under the case of Forrester versus White, hey, that's actually almost decently cited. Supreme Court of an indeterminate year, it gives an example of how governmental administrative functions are not warranted any kind of immunity. Forrester was suing a judge to where it was ruled that judicial immunity should protect only adjudicative functions and that employment decisions are administrative functions for which judges should not be given absolute immunity. This was a function of Congress, though. It was a legislative function. It wasn't a hiring function. It wasn't hiring staffers. It wasn't Congress, contracting with Dunder Mifflin for all its paper needs. If I weren't reading, I'd be speechless. Forrester versus White also stated that administrative decisions, even though they may be essential to the very functioning of the courts, have not similarly been regarded as judicial acts. In the case before us, we think it is clear that Judge White was acting in an administrative capacity when he demoted and discharged Forrester. Those acts, like many others involved in supervising court employees and overseeing the efficient operation of a court, may have been quite important in providing the necessary conditions of a sound adjudicative system. The decisions at issue, however, were not themselves judicial or adjudicative. This is so easy to distinguish, though. Congress, acting in a function of Congress, was doing an act of Congress, not hiring a law clerk, hiring a chief of staff, firing a chief of staff. The defendants, when they committed their acts of fraud, were not acting under their capacities under a 12th Amendment proceeding, but rather they turned the proceeding into a fraudulent administrative act in order to disavow any claims of voter fraud that invariably completed the success of the possible rigged election. Again, the 12th Amendment proceeding is not available under acts of fraud. Once again, how administrative tasks, there's an actual definition for what an administrative act is. You conclusory stating, well, I don't like the way they did it, therefore it's administrative, therefore there's no immunity whatsoever. It doesn't work that way. For the said reasons, defendants in this case have no immunity of any kind. Therefore, this court has subject matter jurisdiction to hear this case. Brunson causes of action must stand. On October 8th, 2021, in the brothers' case, Loy Arlen Brunson's, leave of court to file his third amended complaint was granted. This moots defendant's argument that it wasn't allowed to be filed. Okay. What does fraud vitiate in this case? To this question, defendants give no argument. They don't have to. You saying it's fraud, therefore there's jurisdiction, is conclusory. And even if it worked, that's not the procedure. Instead, they burden the court with over 55 cases in their motion in support of their argument that Brunson failed to state a claim whereupon relief can be granted, and that Brunson has no standing, and that defendants have sovereign immunity, and that Brunson did not establish compliance with any waiver of sovereign immunity, and that Brunson did not get any waiver for constitutional claims, no waiver for promissory estoppel claims, no waiver for any tort claims, and that Brunson lacks Article 3 standing, and that Brunson's claims are barred by absolute legislative immunity, and that Brunson does not have personal jurisdiction over members of Congress not from Utah. But aside from all those fatal flaws from my case, what does fraud vitiate? Defendants do not touch or disturb the following irrefutable facts alleged in the complaint. They don't have to. They didn't serve an answer. They don't have to respond to every single fact because this is not an answer. It's a motion to dismiss, a 12B motion. The fact that Article 4, Section 4 of the U.S. Constitution states, the United States shall guarantee to every state in this union a republican form of government. Voting is the greatest power an individual can exercise in a republic. It is their voice and the way citizens protect their constitutional right and the U.S. Constitution. That an honest and fair election can only be supported by legal votes. This is sacred. It is the basis of our U.S. Republican form of government protected by the U.S. Constitution. The efforts made, as stated in the complaint, that avoided an investigation of how Biden won the election is an act of treason and an act of levying war against the U.S. Constitution, which violated Brunson's right to vote in an honest and fair election. and as such, it wrongfully invalidated his vote. Acts of Congress, or case law, like those cited in the defendant's motion, cannot proceed or have merit when they support treason, acts of war, or the violations of our inherent God-given rights. The only laws Congress has the power to enact are those that protect our inherent rights. The U.S. Constitution was written with honor, respect, and recognition of our Lord Jesus Christ, as memorialized in Article 7, Clause 3, which states, "In the year of our Lord," and as such, the defendants have sworn an allegiance to the author of our freedoms and liberties, our Lord Jesus Christ. The founders of the U.S. Constitution expressed that this document, the U.S. Constitution, was the very instrument set up by God to protect our God-given unalienable rights. The plenary power of the Amendment 9 of the U.S. Constitution nullifies any kind of legal protection that an enemy against the U.S. Constitution claims to have. We've read the Ninth Amendment multiple times. Where does it state that? The plenary power of Amendment 9 also nullifies any interpretation of Amendment 12 that would keep defendants from investigating the claims of voter fraud. If that were the case, that would have been included in the 12th Amendment. It's not. A rigged election is an attack against the U.S. Constitution, especially against the Equal Protection Clause of the 14th Amendment of the U.S. Constitution. Despite the claims of evidence that the November 3rd, 2020 U.S. presidential general election was fraudulent, affecting the President of the United States, the Vice President of the United States, and members of the United States Congress, the defendants intentionally voted against investigating the claimed evidence and conspired to cover up the evidence to fraudulently have Joe Biden inaugurated and Kamala Harris inaugurated as vice president. This act of conspiracy has the same result as an act of war to place into power whom the defendants want, which in this case is Biden. Defendants would like this court to believe that their vote against investigating the claims of fraud of a rigged election does not vitiate their immunity claims because they created and voted for their own immunity claims. No, sovereign immunity is a constitutional. It's in the Constitution. Sovereign immunity is in the Constitution. Where they voted is not for their immunity. They voted where immunity is waived. Defendants' promissory estoppel argument is misleading at best. No. Your promissory estoppel argument is just crazy. We'll go with that, crazy. Defendants, out of context, cited a small fragment of the case of Heartland Biogas. That small segment is known as the holding. They quoted the holding from that case. They didn't need to cite more. As though it supports their argument as an apparent attempt to mislead the court, when in fact, the full context of the case supports Brunson's claims for promissory estoppel. The case states, under Colorado law, what about Utah law? What about United States law? Under Colorado law, the elements of a promissory estoppel claim are: 1, the promisor made a promise to the promisee. 2, the promisor should reasonably have expected that the promise would induce action or forbearance by the promise. 3, the promisee in fact reasonably relied on the promise to the promisee's detriment. And 4, the promise must be enforced to prevent injustice. Obviously, defendants have failed to show that Brunson's promissory estoppel claims are not proper when, in fact, they are. But once again, promissory estoppel is a contract doctrine. He's alleging it as a tort. So, yeah, he just listed the elements of promissory estoppel. But that doesn't apply to torts. Nowhere in this did he refute, because they said, the U.S. attorneys, citing Heartland Biogas, said, this is a contract doctrine. Therefore, it doesn't apply to tort claims. He says, well, that's misleading at best, because here are the elements. But you haven't provided any citation saying, well, it also applies to tort claims. Conclusion. Wherefore, as clearly demonstrated above, all of defendants' immunity claims fail as a matter of law, and defendants fail to demonstrate that Brunson's claims did not satisfy Rule 8. Therefore, defendants' motion must be dismissed with an order that defendants are to answer the complaint within 10 days. Humbly submitted, 13th of December, 2021, by Rayland J. Brunson. Oy vey, that was a mess. But before it was all said and done, we got a short and sweet reply memorandum supporting the motion to dismiss. The United States respectfully submits the following brief reply memorandum supporting the motion to dismiss this action and in opposition to the response of plaintiff, ECF number 20. Argument. Plaintiff has not rebutted defendant's grounds for dismissal. Plaintiff's response memorandum does not squarely address or rebut any of the multiple grounds supporting dismissal of this action spelled out in defendant's opening motion. Like I said, other than all of these things, all of these reasons why the government has properly said this should be dismissed, but fraud vitiates everything, so it's got to stay in, even though I have nothing supporting that. But because fraud vitiates everything, I don't have to even address those. But those grounds were that the court lacks jurisdiction because there was no waiver of sovereign immunity for any of the claims asserted in the complaint. Plaintiff lacks standing to pursue his claims. I mean, Brunson didn't even mention the standing analysis, which claim, unless it was in his list, which claims are also barred by absolute legislative immunity and lack of personal jurisdiction over all members of Congress not elected from Utah. And finally, that the complaint did not state a proper claim for relief. Plaintiff's opposition memorandum sidesteps all of these grounds, claiming merely that fraud vitiates whatever it touches and that somehow, in a manner not explained, the Ninth Amendment to the United States Constitution nullifies the immunity defenses and the 12th Amendment of defendants. Plaintiff's fraud claim is not alleged or explained with any required specificity under Rule 9 of the state and federal rules of civil procedure, either in the complaint or in the opposition memorandum, and is only now supported with 4 older state court opinions from other jurisdictions that are not on point as they concern disputes only between private parties. None of them involved any claim of sovereign immunity or other jurisdictional defenses like those presented here by plaintiffs, or by defendants. Plaintiff then weakly claims that the acts of the defendant members of Congress and Vice President Pence in accepting the electoral votes last January were only administrative acts, not entitled to any immunity under the Supreme Court's opinion in Forrester versus White. But that case is also distinguishable as it dealt with an employment action of a state court judge. Seriously, that was even a state court judge? That makes it even worse for him. But the employment action of a state court judge who had claimed the protection of judicial immunity. Here, we are presented with the performance of constitutional duties of the defendants under the 12th Amendment, which are certainly not mere administrative acts. Forrester has no application here. Finally, the claim that the 9th Amendment nullifies the jurisdictional and immunity defenses of the defendants lacks any legal support or even any persuasive reasoning. It lacks no reasoning whatsoever. No cases or other legal authority were cited to support that argument beyond reference to the 9th Amendment itself. The 9th Amendment's reservation of rights to the people not otherwise specified in the Constitution is fully consistent with honoring the will of the majority of the voting populace, as defendants did in properly accepting the valid electoral votes presented to them. Conclusion: for all of the reasons noted above and in defendant's opening motion, this action should be dismissed. Quite the Christmas present Festivus present, I should say, on the 23rd of December, 2021. And it was ordered. Filed 2nd of February, 2022. It is ordered and adjudged that plaintiff Rayland Brunson's action is dismissed without prejudice. Short and sweet. So, I don't have the judicial memorandum explaining why, and I haven't looked up the appellate briefs, but here in the U.S. Court of Appeals for the 10th Circuit, once again with full multi-page caption, the state court complaint, page 15, 16, 17, page 18, and we get to the order and judgment. Before Judges Timkovich, Baldock, and Carson, circuit judges for the 10th Circuit. Rayland Brunson appeals the district court's dismissal of his action for lack of jurisdiction, exercising jurisdiction under 28 U.S.C. 1291, that's the appellate jurisdiction, we affirm, meaning get lost. Background: Mr. Brunson filed a pro se action in Utah State Court against hundreds of members of Congress, President Joe Biden, and VP Harris, and former VP Pence. He alleged that before accepting the electoral votes on January 6, 2021, the defendants intentionally refused to investigate evidence that the November 2020 presidential election was fraudulent. Mr. Brunson likened defendants' conduct to an act of war against the United States Constitution and this footnote, the star, is from the order and judgment. It says, after examining the briefs and appellate record, this panel has determined unanimously to honor the party's request for a decision on the briefs without oral argument. This case is therefore submitted without oral argument. This order and judgment is not binding precedent, except under the doctrines of law of the case, res judicata, and collateral estoppel. It may be cited, however, for its persuasive value, consistent with the Federal Rule of Appellate Procedure 32.1 and 10th Circuit Rule 32.1. So that means this isn't law for anything but this case. Anything else is just persuasive. So, Mr. Brunson likened defendants' conduct to an act of war against the United States Constitution that violated their oath to uphold the Constitution and his right to participate in an honest and fair election. He advanced constitutional tort and promissory estoppel claims and sought almost $3 billion in damages. He also asked for injunctive relief, including removal of defendants from office and reinstatement of Donald Trump as President of the United States. Defendants removed the case to federal district court and filed a motion to dismiss under Federal Rules of Civil Procedure 12b1, lack of jurisdiction, and 12b6, failure to state a claim. Mr. Brunson filed an opposition to the motion to dismiss. A magistrate judge issued a report and recommendation that the action be dismissed for two independent reasons. One, Mr. Brunson lacked constitutional standing because his claimed injury was not concrete and personal to him, but only the same as any citizen. And two, 11th Amendment sovereign immunity barred the claims against the defendants, who were sued in their official capacity only, and Mr. Brunson failed to identify any statute or other express provision that unequivocally waives that immunity for his claims. Footnote 1. The magistrate judge provided various alternative grounds for dismissal, but we need not consider them in this appeal. Meaning, this is a strong enough reason for appeal. Let's just go with that. Mr. Brunson filed a timely objection to the recommendation, arguing only that the magistrate judge did not address the arguments in his opposition to the motion to dismiss and thereby deprived him of due process. So, the problem I see with so many pro se litigants, we see it from delete laws, we see it from sovereign citizens, they scream, due process, you've got to give me due process. And yes, everyone is afforded due process. It's guaranteed in the Constitution. The problem is due process is not necessarily your process. The district court overruled the objection, concluding there was no authority for Mr. Brunson's proposition that a reviewing court must specifically address arguments made in a brief. Well, that's a nicer way of saying you're getting due process, you're not getting your process. And finding that he was afforded procedural due process by receiving notice of the motion to dismiss and having a reasonable opportunity to respond. Notice and opportunity to respond. Due process. Because Mr. Brunson did not assert any objections to the magistrate judge's conclusions that he lacked standing or that the defendants were entitled to sovereign immunity, the district court determined that he had waived any objections to those conclusions. The court then adopted the recommendation in full, dismissed the action without prejudice for lack of jurisdiction, and entered a separate judgment. This appeal followed. Discussion. We review de novo, meaning we review new. De novo, new. We look at it not just for review abuse of discretion, but we actually look at the law and facts. So we review de novo a district court's dismissal of an action under Rule 12b1, Chance v. Zinke, 10th Circuit, 2018. We construe Mr. Brunson's pro se filings liberally, but we may not act as his advocate. Yang versus Archuleta, 10th Circuit, 2008. Mr. Brunson first argues that the district court's separate judgment is invalid because it fails to set forth the legal basis for the judgment. Footnote 2. The body of the judgment states, it is ordered and adjudged that plaintiff Rayland Brunson's action is dismissed without prejudice. This argument is frivolous. Federal Rule of Civil Procedure 58 requires a district court to set out its judgment in a document separate from the court's explanation of the reasons for the disposition. See, I'm not even going to attempt that name, versus Manufacturers Traders Trading Co. 10th Circuit 2008. The district court's judgment did just that, and the reasons for the dismissal were thoroughly explained in the recommendation and the district court's order adopting it. Mr. Brunson next contests the merits of the magistrate judge's standing analysis, but as noted, in his objection, he did not address the standing analysis. He only faulted the magistrate judge for not discussing the arguments he raised in his opposition to the motion to dismiss. This court has adopted a firm waiver rule with regard to objections to a magistrate judge's findings and recommendations. United States versus 2120 East 30th Street, 10th Circuit, 1996. To avoid waiving appellate review of factual and legal questions, a party's objections to a magistrate judge's report and recommendations must be both timely and specific. This means the objection must be sufficiently specific to focus the district court's attention on the factual and legal issues that are truly in dispute. Although Mr. Brunson's objection was timely, he did not specifically challenge the magistrate judge's standing analysis. The firm waiver rule therefore applies unless the interests of justice dictate otherwise. Footnote 3. This rule does not apply when a pro se litigant has not been informed of the time period for objecting and the consequences of failing to object. But Mr. Brunson received the proper warning in this case. Factors this court has considered in determining whether to invoke the interests of justice exception are a pro se litigant's effort to comply, the force and plausibility of the explanation for his failure to comply, and the importance of the issues raised. Morales-Fernandez versus INS, 10th Circuit. Mr. Brunson makes no effort to explain why he failed to specifically challenge the magistrate judge's standing analysis. The first two factors, therefore, weigh against invoking the exception. In considering the third factor, the importance of the issues raised, we can conduct an analysis akin to plain error review, so not de novo. Plain error occurs when 1. There is error, 2. That is plain, which 3. Affects substantial rights, and which 4. Seriously affects the fairness, integrity, or public reputation of judicial proceedings. We cannot say the district court's conclusion that Mr. Brunson lacked standing is plainly erroneous. As the magistrate judge explained, the relevant Article 3 standing inquiry is whether the party seeking relief has alleged such a personal stake in the outcome of the controversy as to assure concrete adverseness. Quoting U.S. versus Richardson, Supreme Court 74, and a plaintiff like Mr. Brunson who raises only a generally available grievance about government, claiming only harm to his and every citizen's interest in proper application of the Constitution and laws, and seeking relief that no more directly and tangibly benefits him than it does the public at large, does not state an Article 3 case or controversy. Lujan versus I assume that's Defenders of Wildlife, Supreme Court, 1992. Thus, the district court did not plainly err in concluding Mr. Brunson lacked standing. Mr. Brunson's argument does not persuade us otherwise. Essentially, he contends that because he alleged the defendants acted fraudulently and because fraud vitiates whatever it touches, he has an unfettered right to sue the defendants, and any federal law or case is inapplicable if it supports treason, acts of war, or the violation of Brunson's unalienable God-given rights. But none of his supporting authorities suggests that allegations of fraud, acts of war, or the violation of allegedly inherent, unalienable, God-given rights relieve a plaintiff from demonstrating Article 3 standing. Finally, Mr. Brunson briefly mentions that the magistrate judge's 11th Amendment sovereign immunity analysis, but he develops no argument addressing the magistrate judge's reasoning other than to direct us to his opposition to the motion to dismiss. That is insufficient to meet this court's requirements for developing an argument on appeal. See U.S. v. Patterson, 10th Circuit, 2013. Thus, setting aside the antecedent inquiry whether the firm waiver rule precludes our review of this aspect of the dismissal, we conclude Mr. Brunson has waived appellate review of the sovereign immunity basis for dismissal due to insufficient argument. Footnote 4. And even if we were to overlook this obstacle to review, Mr. Brunson's lack of success on the merits of his arguments relating to standing is, by itself, a sufficient basis for affirming the district court's judgment, regardless of the merits of his argument relating to sovereign immunity. See Morrell versus Shalala, 10th Circuit, 1994. Conclusion. The district court's judgment is affirmed. Entered for the court, Bobby R. Baldock, Circuit Court Judge. So, unhappy with the Circuit Court, the 10th Circuit, Rayland Brunson, Clerk, United States Court of Appeals for the 10th Circuit. Dear Clerk, the petition for a writ of cert, I don't pronounce that word, it's cert, in the above entitled case was filed on October 20th, 2022, and placed on the docket October 24th, 2022. Sincerely, Scott S. Harris. So basically, this is Supreme Court of the United States, Office of the Clerk, saying, hey, we want to appeal. We're applying for cert, for permission to appeal to the Supreme Court. Well, I've got bad news for Mr. Brunson, because here we have the order lists from the Supreme Court on Monday, January 9th. Well, here we have the summary dispositions. So Escobar, hey, he had his petition for cert granted. Kamahele had his cert granted. But we proceed down to page 3. Cert denied. NSO Group had their cert denied. Spectrum Northeast, cert denied. Let's see, where is it? whole bunch of people had their search denied. Either way, I'm tired of looking. Cert was denied. But fear not. Fear not, because let's go back to the Salt Lake Tribune, where this all started, for me at least. And once again, by Brian Schott, Supreme Court rejects Utah brothers' lawsuit seeking to return Donald Trump to the White House. Now, not much more needs to be said. But the Brunsons did not immediately respond to a request for comment about the ruling. But on social media, Rayland Brunson set the stage for Monday's denial. Don't think for a second that my brothers and I are not prepared for denial. We've got plenty of chess pieces still at play, and we still have our queen, he wrote on Facebook. But let's read the whole statement. Hello, my fabulous patriots and friends. Okay, here is the deal with tomorrow's decision. The Supreme Court's schedule of posting decisions is always the Monday following conference. So we won't know anything until Monday. Now, don't think for a second that my brothers and I are not prepared for a denial. We've got plenty of chess pieces still at play, and we still have our queen. Through hard knocks, we have learned how this political litigation game works. So keep up the prayers and your letters to the Supreme Court. You count. We love every one of you. Thank you for your wonderful support. Following the decision, Rayland expressed disappointment on Facebook, but said they planned to ask the court to reconsider. Is that the queen on his chessboard? I wonder. Well, for those of you who stuck through all 3 hours and 52 minutes of that delusion, what's wrong with you? I mean, seriously, go get help. That was rough. But thank you. Seriously, thank you. It was delusional, pseudo-legal quackery, other than the U.S. Attorney's motions. Those were very well written. I liked them. But yeah, this was just utter and complete nonsense. So I hope you learned something. I hope you enjoyed it. I hope you like, share, and subscribe. Do all the YouTubey things that I always forget to mention right at the beginning, so that only those of you who stick around to the very end know to do it. So, but either way, I will see you guys very soon. But I think I'm exhausted, so I'm going to call it a night. So have a good one.